Welcome to the first meeting in 2025 of the Delegated Powers and Law Reform Committee, and I'd like to wish everyone a happy new year and all the best for 2025. I'd like to remind everyone to please switch off or put to silent their mobile phones and other electronic devices. The first item of business is to decide whether to take items 6, 7 and 8 in private. Is the committee content to take these items in private? Yes. And our agenda item number 2, we're considering instruments subject to the affirmative procedure. No points have been raised on the draft Movable Transactions Scotland Act 2023, Amendment Regulations 2025, the draft Registers of Scotland, Fees and Plain Copies, Miscellaneous Amendments Order 2025, and the draft International Organisations, Immunities and Privileges Scotland Amendment Order 2025. Is the committee content with these instruments? In relation to the draft International Organisations, Immunities and Privileges Scotland Amendment Order 2025, does the committee wish to welcome that this instrument fulfils a commitment by the Scottish Government to correct an error in the International Organisations, Immunities and Privileges Scotland Order 2009, which arose from an error in SSI 2024-158. That was the International Organisations, Immunities and Privileges Scotland Amendment Order 2024. Okay. Under agenda item number 3, we're considering instruments subject to the negative procedure. No points have been raised on SSIs 2024, 371, 374, 376, 377, 379 and 381. Is the committee content with these instruments? Yes. Under agenda item number 4, we're considering instruments not subject to any parliamentary procedure. No points have been raised on SSIs 2024, 373, 375 and 378. Is the committee content with these instruments? Thank you. And with that, I'll briefly suspend the meeting to allow the witnesses to join the table. Moving on to agenda item number 5, today we are taking evidence on its inquiry on the framework legislation and Henry VIII powers. For our first panel, can I welcome Dr Ruth Fox, the Director of the Hansard Society, and Dr Fox is online today. Dr Dexter Govan, the Director of Research at the Constitution Society, Dr Gretz, the Lecturer in Public Law at the University of Strathclyde, Professor Colin Reid, the Emeritus Professor of Environmental Law at the University of Dundee, Dr Andrew Tickell, the Head of Department for Economics and Law at Glasgow Caledonian University, and Professor Richard Whittaker, Parliamentary Academic Fellow at the University of Leicester. Welcome to you all. And can I remind all panellists to not worry about the microphones because they'll be dealt with automatically. And if you'd like to come in on a question, just please raise your hand or indicate to the clerks. And that there's no need to answer every question. Just simply, if it's not for you, just indicate it's not for you. But if you, at the end of the session, if there is anything that you feel as if you haven't said on the record that you would like to contact the committee about afterwards, then please feel free to do so. So we'll just open the session, and so obviously we've received a number of submissions, certainly submissions from yourselves and others, and I think it's fair to say that there's been it's been quite an interesting read of a situation that no doubt most folk will probably think is really quite a dry subject. But it's something that, because of the work of this committee, it does come up from time to time, as you'll be very much aware. So certainly there does appear to be a broad consensus among those who have submitted evidence to the committee on what framework legislation is. Do you think that there should be a definition of framework legislation agreed by the Scottish Government and also the Scottish Parliament? Dr. Gretz.
Well, first of all, many thanks for the invitation, and I would like to also welcome the opportunity to contribute to the work of the committee. I think that it's extremely important that the committee is conducting this inquiry. And as far as the question is concerned, and as I argued in my evidence, in my written evidence, it seems to me that the proliferation of different concepts as far as this subject is concerned is not helpful and might lead to some confusion. My view would be to rather stick to skeleton bills rather than framework legislation or maybe headline legislation, as is the case in Wales. And as far as the concept of skeleton legislation is concerned, my view would be that there are two main distinctions that are relevant. The first one is to distinguish between skeleton legislation, where the bill as a whole is skeleton in form, and skeleton provisions, which is an important distinction for the purposes of the scrutiny work of the committee. And secondly, to consider that the idea of a skeleton legislation or a skeleton provision is a spectrum, where there will be very extreme examples on one side of one end of the spectrum, where we would only have potentially a statement of policy intent or policy aims with no fledge whatsoever in the bill or in the provision, and we will go all the way down to other instances where there will be more policy decisions contained either in this skeleton legislation or skeleton bill or in the provision. So, since this is a spectrum and there will be different possibilities, it will be rather difficult to have one single concept. But if there is something that characterizes all of these instances, is the fact that key policy decisions are left for ministers to decide at a different time in delegated legislation.
Okay, no, thank you. Professor Whittaker, in your submission, you touched upon the framework, skeletal and also headline, obviously headline in the Welsh Senate. So how, in terms of what you've highlighted in your submission, how do you feel that would deal with the points raised by Dr. Gretz?
Yeah, I think one of the things I've tried to do is to measure the prevalence of these bills, and having all these different terms makes that more difficult. I mean, maybe that's just a problem for people who are trying to measure it and not necessarily a fundamental problem. But yeah, I think that it is difficult to pin down when something crosses over the line from being a bill that just has some delegated powers in it, and maybe some of those are a bit contentious, to ones which are where the essential substance of the policy of the bill, the whole substance of it, is being decided through delegated legislation. So I think if there was a reduction in the range of terminology used, that would certainly make it easier to follow the progress of these bills, and to then follow the delegated legislation that follows, that is given, that comes from the Parent Act in the first place. But clearly there is a spectrum there, and we do have this different sort of terminology being used. The Scottish Government has used the term framework bill in some cases in its policy memoranda, and that's interesting, I think. And I've seen it used in the Australian Senate as well. And so there's debate about whether this is the right term or not, which I think you were introducing that question about whether it suggests things it puts a more positive light on things rather than the term skeleton bill. But yeah, I think if there were fewer different terms being used and a clear definition being agreed by government and Parliament, in all cases, that would be really helpful for tracking these bills.
Anyone else on the panel?
Yeah, I mean, I think the language of what we were describing it as, it's not a question of objective description. Skeleton is a term of abuse. It's designed to be a critical framing of powers of this kind as an inappropriate transfer of power from the legislature to the executive, whereas framework sounds nice and friendly and sensible and planning and administrative. And headline sounds even more press-orientated compared to anything else and probably tells you something about how governments approach policy making, that it is about the headline that we've passed legislation on this issue. So you won't find an objective account of it. Really, we come back to the core point, which is what is the appropriate use of delegated powers? And the challenge for you and for parliaments everywhere is sometimes that it is very appropriate, very helpful and very instrumentally useful, but increasingly we're seeing evidence of more and more powers being centralised in the executive hands, leaving you invited to pass legislation without any real idea of what it will mean in practice. And that, for me, I think is implicit in any definition or even title that we give such provisions.
Okay, thank you. Dr. Govan?
I'd be happy to echo the calls of my colleagues there. I think whether you call it framework, skeletal, hyperskeletal, jellyfish, as I've seen it termed elsewhere, you know, we shouldn't lose sight of the key problem, which is the inappropriate extension of this legislation, which seems to become more prevalent, not simply in, and it's worth saying this isn't a Scottish problem by any, or a uniquely Scottish problem by any stretch of the imagination. We're seeing it at Westminster, we're seeing it in Wales, we're seeing it everywhere. But I mean, it would be useful if you could come up with a great definition of it, but I share some of the scepticism of my colleagues that identifying a definition which covers everything is likely to prove very challenging.
Thank you. Professor Reid?
Echo the same points. There's a question of why wanting to have a definition. If it's, is it simply to help us and you discuss these things, or is it actually going to make a difference in procedural terms? And if it's going to make a difference in procedural terms, there's a huge challenge because of what my colleagues have said about the spectrum, the mixture within the one bill of broad provisions, narrower provisions, very precise ones. So thinking about why you want a definition is a part of the thinking.
Okay, thank you. And Dr. Fox?
Yeah, I would just echo Professor Reid's point and say, if you want to, if you like, badge a piece of legislation as framework or skeleton or whatever terminology you use, the question is to what purpose in procedural terms. I mean, it's nice to make it easier for us as researchers, that would be great, but in procedural terms for the legislature, it's important. And who is going to be asked to make that judgment as to whether something is, for example, one route would be to certify a bill by the Speaker or presiding officer as framework, because certain procedural results would follow from that. So you need to think about, well, who's making the judgment and how, bearing in mind the issues that colleagues have highlighted.
Okay, thank you. Jeremy Balfour, wanted in.
Good morning and Happy New Year to everybody. Just going back to Professor Whittaker's opening remark, I wonder if I could just follow it through slightly. Do you think historically we now have more skeleton framework, whatever we want to describe them, than we did in previous generations, both here in Westminster but also in other jurisdictions across the world? And why do you think that is the situation? Is it because people don't want to make difficult decisions and leave it to others to make that decision? Or is there some more philosophical view for why these have become more prevalent?
Yeah, I mean, I think I wouldn't want to claim with total certainty that there's been an increase because it hasn't been measured brilliantly well over time. And one of the things, when you look into this, is you discover it's not a new thing. So there's a report from the 1930s that talks about this as a problem in the UK Parliament. But in the data that I submitted, I've tried to measure it in the period since 1991, and there does seem to be an increase in Westminster, at least. I haven't got over time data for the Scottish Parliament and Welsh Parliament. I've only got more recent data for those. But yeah, there's a big increase around the time of Brexit. And part of this is, you know, if you're asking us to give examples of where it's been deemed acceptable, in some cases, in some of those situations, the opposition at Westminster was saying, OK, we understand that you need to have some kind of framework in place. You are trying to, you don't know the details of a policy yet, but you're trying to be able to implement that policy quickly, so you might need secondary legislation powers to do that sort of thing. But even if you sort of split that period that I looked at in half, and so it's not quite a pre- and post-Brexit thing, you still see an increase. And of course, the COVID-19 pandemic led to a lot of discussion about making legislation quickly, which kind of came on the back of Brexit. And we have seen this product regulation and metrology bill, which has been described as a skeleton bill by the Delegated Powers and Regulatory Reform Committee in the House of Lords since we've had the new government in power. So, yes, I think it's fair to say that there has broadly been an increase, although it doesn't look like a simple increase of more and more every single year, one after another. But in broad terms, there is an increase in this. And it seems to be quite prevalent. It seems to be similarly prevalent here as it is at Westminster, more so in the Welsh Parliament and the Senedd. As for the reasons why, yeah, I mean, I think Brexit is part of the explanation, but also there are suggestions in other research, particularly by the Hansard Society, and I see to Dr. Fox on this, but that there's just more pressure on governments to get legislation through quickly, particularly perhaps at the start of a legislative term. That they need to be seen to act fast. And so bills sometimes end up making it into the process, but without the detail having been fully worked out. And that seems to be part of the explanation. Also some sense that particularly since Brexit and COVID, there is increased pressure on civil servants to generate and to draft bills more quickly than perhaps they did before. So those seem to be some of the reasons. I'm not sure they fully explain the differences that I found between the parliaments I looked at. But yeah, I think there is a general increase that we can detect.
Okay, thank you. Just in terms of, sorry, it's Ros. Sorry, my apologies. Ros McCall.
No, thank you very much, Convener. And again, I'll just do a Happy New Year. I'll get that out of the way. Thank you very much for your attendance. This is a really interesting sort of line of questioning. I'm going to try and follow on some of it. Because Professor Whittaker, I'm sorry, I'm coming back to you. You're doing a lot of talking. But you mentioned earlier in your initial comments that when does it cross the line? Is it basically because there is no line? That's why we've got that problem. We don't know when it crosses the line. So should there be some form of threshold? Should it be that we actually state, no, this is when it goes to framework or skeleton, whichever form you want to call it, or this is where it needs to be a primary legislation process? Would it be sensible just to create a threshold?
You could try to do this, and political scientists have done this, trying to measure it in the past. So they've created things like a delegation ratio, where you look at the proportion of clauses in a bill that are delegating powers. The problem with that is it sort of depends a bit on the way bills are divided up into clauses, because that affects the denominator in the equation when you're calculating that. And so it doesn't necessarily always work brilliantly, because if people start dividing things up into more shorter clauses, then you're going to find lower proportions for the same number of delegated powers or something like that. So, yeah, that can be a tricky way of doing it. I suppose the way that the Delegated Powers and Regulatory Reform Committee in the House of Lords have done it is on a case-by-case basis, and they have this definition, which is that where the provision on the face of the bill is so insubstantial that the real operation of the Act or sections of it would be entirely by regulations or orders made under it. So it's about the substantive importance of the policy that's being made in delegated legislation. I think that's the crucial factor, but that you might need to make that on a case-by-case basis. Absolutely.
And equally to other panel members, do you think that's a sensible way to go? Nodding heads. Yeah, Dr. Govan.
If I might, I think it's the only way to go, because the other problem with doing some kind of ratio is it doesn't actually measure the consequence of, you might only have one delegated power in a bill, but if that delegated power is so important or consequential, then really that's significant enough in its own right to make it a problem or an issue.
Yeah, because it's about the quality of the power. It's not about the number of powers, because you might, in fact, have, say, 6, 7, 8, 9, 10 quite well-bounded, clearly focused powers around agriculture or something like that, whereas you could have one nice little provision which gives the minister vast amounts of power. So I think, again, you're sort of almost externalising the question in a way, as if there's an objective route out there for you to just put legislation against and say, aha, this is framework, this is skeletal, or this is jellyfish-like, or whatever we're describing it as. And that's not how it works, because ultimately it's about values. It's not about an objective thing. It's about this Parliament and parliaments everywhere saying, how far and when are you prepared to give ministers, or the people to whom ministers delegate these powers, powers to shape public policy? Yeah. How blank a cheque effectively are you prepared to give the Scottish Government? And that fundamentally is the question in play here. It's not even really about volume or numbers. It's about that judgment, and it's ultimately a judgment, I think.
Yeah. Thank you. So, My apologies.
move on.
Yeah.
I know Daniel had a supplementary
Yeah,
in this.
my apologies.
Yes, and actually, to some extent, what I was going to ask is actually, is it helpful to be thinking about this as being framework versus everything else, or is it actually about how powers are framed? So, in a sense, you answer, but I wonder if there's a follow-on question. I think we can all, in our sense, in our heads, kind of frame a spectrum where, on the one hand, you have legislation that has a power to set a rate or a value, and that can change over time, and at the other end, powers that could essentially give ministers the ability to make certain actions criminal, and we could see that is kind of very problematic. Are there sort of features of the sorts of powers, that might be the one power in the legislation that you would look at, whether that's about the type, or is it also about the framing? Because one of the other things that I'm sort of concerned about is that I think secondary legislative making powers should have guardrails. So is it about the type, or is it about the way that they're framed, or is there sort of a taxonomy we should have on our head to identify the clauses that are potentially problematic? Andrew Tickell, you seem to be nodding the most, so I'll ask you.
I'm just naturally obliged in that way. I think there's a few things one can say about that. The first is, what is the nature of the delegated power, which will depend on the issue and the context. So if you're talking about emergency powers in the context of a public health pandemic, you might analyse that differently from, say, a power giving ministers the ability to set a given level of benefit. So that, I suppose, is the first thing I would say. The second is that there's a couple of guardrails that I think are particularly important. One you've already highlighted, which is the creation of criminal offences, that I think we should be very concerned about executive fiat effectively making things criminal which are not put before Parliament. And critically, I think that parliamentary process, from my point of view, is important, not simply for you as MSPs to get a chance to test the evidence, but it's the way that everyone else in civil society finds out about what's going on and frequently raises issues which has not occurred to the government or to parliamentarians to consider. There's a third element, I think, which is also important here and doesn't always get highlighted, and it's about the human rights framework around this. A range of forms of secondary legislation can impinge on European Convention rights, and just like this Parliament, the Executive, the Scottish Government, are obliged to pass measures which are consistent with ECHR norms. And one of the key but often overlooked parts of the ECHR is the requirement that any restriction on rights which are qualified should be according to law. And that means sufficiently legally accessible and clear to the people who are affected by it. That's one area where particularly secondary legislation can be problematic. During the COVID pandemic, the law changed and no one knew about it, except for an announcement by the government which had never been put before Parliament. Now, maybe that's justified in the context of an emergency and a pandemic, but it is illustrative of some of the core fundamental issues here, which are about democratic accountability, legal certainty, and due process, frankly, for law being created.
Professor Reid, would you like to?
Yeah, and just say that you need to appreciate that there are problems here, even in something that seems as simple as creating a criminal offence. Is that what you're actually meaning there? Because if you slightly change the boundaries of a criminal offence, then you're making criminal things that weren't before. And if you're talking about things like construction and use of whatever, vehicles, I know it's a Westminster matter, but that sort of thing, that's something where there may be a criminal offence, but you're wanting it to be easy to change and update all the time for technical reasons. But by changing the narrow changes in the boundary are bringing into the criminal law people who were outside it before. So even something that sounds clear and neat as creating a criminal offence actually may have difficulties.
I guess following on from that, I'd be interested to bring Professor Whittaker on this point, is that we're not going to be able to come up with kind of a hard and fast test that you feed the legislation into a computer and it says, green light, this is fine, or red light, no, this is framework legislation. But, do you think, as Dr. Tickell just pointed out, there are at least a set of principles that we can use to make that judgment? And yeah,
I think so. I should say I've come at this as a political scientist rather than a legal scholar, and I think that gives me a slightly different approach from others. And so I'm perhaps too interested in trying to measure things in some ways. But yes, I think that it's very important to say that you can try to measure it with numbers, but it won't tell you about the quality of the legislation, and that is at the heart of it. So I totally agree with what's been said on that point, that it needs it needs a piece of legislation to be looked at in the context of other legislation in that area, and in terms of its effects on things like human rights and whether it's constitutionally important, for instance, to determine how significant the policy that's being delegated is. And I think this is why, for example, the committees in this Parliament and elsewhere that have looked at these sorts of bills sometimes, as others have said already, point to certain parts of a bill being skeletal rather than the whole thing. So I think it's important, and I should say in the measures that I did, that included bills where only some of it was deemed to be skeletal. So I think, that's an example where you have a skeletal part of a bill where you say, well, actually, not the whole bill is a skeleton, but parts of it are, and that focuses attention on the quality rather than the quantity.
Okay, thank you. Back to Ross McCall.
And thank you. And there we go. I'm mic'd up now. Thank you very much. That's very interesting. We've already highlighted and spoken about the fast pace and the fact there's more frequency of skeletal framework bills coming through. Dr. Fox, can I go to you on this one? Because there's a sort of simplistic question, first of all, in my mind, which is, the world is moving faster than it ever has before, in the extent that we have modern technology, we have advancements that are progressing it. Could that be part of the reason why this need to be seen to be focusing quickly and adapting quickly in legislation? Is it just because exponentially everything is moving faster?
I think that's part of it. And certainly at Westminster, if you look at some of the examples of bills, two, for example, one on automated cars and how you regulate those at Westminster was judged to be a concern in relation to framework legislation. But it was accepted that, without knowing how that technology is going to develop, it was very difficult to pin down the detail of the policy. Another one that's been cited is, for example, the development in England of the devolution model in terms of mayoral authorities. And because those were being negotiated separately, you couldn't have a bill that set a sort of a framework for everyone, and therefore you needed a particular legislative framework that allowed for deviation and difference. So those are two examples. And I think if you look ahead, this is one of the concerns of our delegated legislation review in terms of how we're thinking about this problem, that if you look at things like artificial intelligence, as you say, technology, even in areas of science and medicine and so on, things are moving incredibly fast, and our ability as parliaments to stay ahead of that curve is very, very difficult. I think governments are finding it more difficult to do the sort of the legislative planning for that and to build in the time necessary within the electoral cycles. So from our perspective, given the difficulties about drawing the line, the boundary between what should be in primary and delegated, given that concern about speed, we think if you rather than focusing upstream so much on the creation of the bills and the powers, if you focused more on the scrutiny of the regulations once they come forward and got that aspect of the process right, we'd have a better opportunity to scrutinise and to influence the legislation than we do with trying to prevent government from bringing forward framework bills. Because at the end of the day, it's creating a ratchet effect. One of the reasons why I think there's possibly more is it creates a precedent. The ratchet effect means that governments and ministers think, well, so-and-so brought forward that bill, why can't I do the same? And unless a parliament is going to have a procedure, if you like, a gateway, to prevent a government bringing forward its bill because it doesn't like the form in which it brings it forward. So something like a Legislative Standards Committee, which said at first reading, this is framework, we don't think those powers should be in the bill in that form, we want more policy detail, go away and do more work. Unless a parliament is going to do that, I think the problem is going to continue. So focusing more on the procedures at the sort of later stage rather than at the beginning would address that.
Yeah, and if I could just come back on that. So consequences, obviously you're highlighting that one of the consequences is lack of scrutiny and this ratchet effect, etc. Are there other consequences that we're missing? That you would say we're missing, or is it literally just that ability to scrutinise properly?
the ability to scrutinise properly. It certainly undermines the ability of parliamentarians to know how the powers are going to be used at the time at which you're being asked to grant authority to the government to have them. And we've made the point that in the past, powers sit on the statute, but not just for a year or two. They sit there for decades unless they're repealed. And a politician, a minister of a different political stripe will be able to exercise those powers in a way that perhaps the minister that introduced them and sought them didn't intend. And we certainly, there are examples of that. So hence, that in particular is a problem. But again, if you can frame the procedures at the end point of the process for the regulations better, you can address that.
Yeah, thank you for that. My apologies for the word "just." I think that diminished the scrutiny role in my language there. Dr. Given, your hand up. So yeah, please.
I'd echo what Dr. Fox has said, and the Hansard Society report is really important in that regard. Something we speak a lot about at the Constitution Society, though, is proper scrutiny improves the quality of legislation as well. So I think when you talk about what are the consequences of this, it is poorer legislation by and large going through as well. It's something we should be mindful of.
And is there anyone else that wants to? Yeah,
this is just a small footnote to what Dr. Fox just said, because if we think about the current procedures for the scrutiny of secondary legislation, these are procedures that were designed in, if my memory helps me, is in 1946 in the context of a different world where there were different challenges, and those procedures have continued, and the procedures that are operating here in Scotland, we are negative and affirmative, are pretty much designed along the lines of those procedures that were originally set up for the mid-20th century, and the sort of challenges that you were referring to in terms of artificial intelligence and technology might not be suited to these structures. There have been obviously improvements along the way. For instance, there are super affirmative procedures that introduce additional safeguards, or currently there are sifting procedures when there are concerns about whether the negative procedure might be appropriate or not. But perhaps, as Dr. Foss was saying, there is room for having a broader reflection about how procedures downstream might work, so that they enable this committee, actually, because this committee starts with that, to perform a proper scrutiny of secondary legislation.
Right. Thank you. Thank you.
Thank you. Jeremy Balfour.
Yeah, good morning again. I think we are kind of trying to work out how do we as a parliament hold the government accountable when we have these framework bills. And I think everyone recognises the issue, but I think we're struggling slightly to find the solution to the issue. So I wonder, with the expertise around this table, what would you suggest to us as parliamentarians of how do we, when we see a framework bill come forward, hold the government to account for it? And again, I'm afraid, Andrew, because you're smiling and nodding, I'm going to start with you.
Well, that's a straightforward question. I think firstly the thing to say is that framework bills are problematic because they do not allow you to hold the government to account. I mean, that is at the heart of why they are problematic. And the point that Dr. Fox just made there, that when you give the executive power and the executive changes, a new executive can use existing powers in ways that were never discussed or mooted at committee. Now, you're probably quite used to this. It's actually in the primary legislative process, in the area of criminal law, for example, where I've given evidence before, it's quite common for MSPs to be told by police officers, prosecutors, and indeed the Scottish Government that legislation will be used in particular ways, and for you to be given reassurances that certain things would never fall within the contemplation of Police Scotland or prosecutors. Now, in general, I am personally extremely suspicious about this, because the law is what the law is. The law says what the law says, and it empowers the people the law empowers, and that fundamentally is the problem with framework bills. I was very struck by one of the quotes, I think, from Lord Lisvane that you got from your trip to London, where he said, effectively, what you've asked me is how do you mop up better instead of turning off the tap and stopping the room being flooded. Now, maybe that's an impossibility. As Dr. Fox said, there's a reason why we have all of these framework bills, that they're about the modern state. It's not because the executive necessarily is malicious or intending to cause difficulties. It's because the administrative state is vast, the demands are huge, the parliamentary process is slow and difficult and can sometimes leave you stuck with legislation which doesn't capture emerging forms of modernity, such as social media and all of those other types of changing technologies, changing medicine and so forth. I suppose what I would say is it's important for us not to confuse efficiency or arguments for efficiency with effectiveness, and oftentimes that is how these things are framed by the government.
Can I just come back with a couple of thoughts? Would sunset clauses help on these types of legislation? Have we looked at saying we'll grant this, but for a limited period of time, to force the government, the executive, whether it's a new government or the same government, to at least then justify it? Would that be a possibility, or is that just going to add more administration to a busy timescale? Yep.
Personally, very sceptical of them. We've got the example just now of the infrastructure levy. The Planning Act gives a sunset clause in introducing the infrastructure levy. Progress has not been made, but that leaves everybody uncertain. You know, we're now, I can't remember how long we are. I mean, we're about, I think, less than a year from the deadline. Does that mean nothing, since nothing's happened now, does that mean nothing's going to happen? Or is there going to be a terrible rush at the end and things happening? I'm not sure that's conducive to good governance, that the artificial pressure created by that when, whether for good or bad reasons, the expected progress hasn't been made and you've got a strict deadline.
Okay. Yeah, sorry.
Yeah. Could I come in on the earlier point about whether you try to deal with this at the point of government designing legislation that's framework, or whether you deal with it further downstream? I think, yeah, it may be part of the solution is about, even if we can't stop governments from introducing framework legislation for the reasons that have been given, it's about getting governments maybe to be a bit more honest and upfront about the fact that that is what they're doing, which, to be fair, in some cases they do that. They say, this is a framework bill which is just going to set out a set of ideas here but with no detail in it. And I think then if governments would do that more frequently, I suppose it would require a sense that perhaps they don't do it because they think they shouldn't be introducing framework legislation, but if we could get over that and say, OK, it's going to happen in some circumstances, then you could label something in that way, and then you might be able to design procedures further downstream, like the Hansard Society have suggested, which then give you a chance to say, oh, by the way, this statutory instrument came from a framework bill, and some different procedure applies to it.
Dr. Fox.
Yeah, just to the point about how you might scrutinise or constrain the government in terms of bringing forward framework bills. And the example has been briefly mentioned, enhanced and super affirmative procedures. I mean, one of the byproducts of framework legislation and the increase in it over time has been, particularly in Westminster bills, that the House of Lords in particular has sought, because there's not the policy detail to scrutinise, they scrutinised the powers, and they scrutinised and looked at ways to constrain ministers in the use of those powers at a later date through these enhanced procedures. But what we've ended up with then is a proliferation of different versions, different models, and there's now, I think, 16 powers in 16 procedures in 15 acts, and depending upon what characteristics you use to judge them, sort of at least nine versions, everything from more time to scrutinise, sifting, considered by a specialist committee, even in one case a committee veto on a regulation that emerges under some of these very, very broad powers. And one of the problems with that is then that you're introducing extra complexity, which is problematic both for civil servants and for the legislature. But there is some evidence that it does constrain ministers in using those powers in the future. So, for example, the Legislative and Regulatory Reform Act, which was actually introduced under the Blair government, that has the highest procedural level of a super affirmative procedure. And it is rarely used because the process is so so time consuming that frankly it is better for ministers to put primary legislation, as quick to put primary legislation through. And in the review of the Act, they've acknowledged that. So there've only been sort of 40-odd legislative and regulatory reform orders. Similarly, when the Public Bodies Bill was introduced by the coalition government in 2010, 2011, there were far fewer public bodies orders than they had anticipated because the process was onerous. So that's one example. You can constrain the government using the powers by adding procedural thresholds, procedural constraints into the process. But then from the government's perspective, that hinders their policy making and they have to find alternative routes. So that's one example where it's happened, but it has made the process, the procedural process, more complicated.
That's helpful. Just one further question, Rich. I mean, the justification from this particular government is that they want to involve as many stakeholders, as much of the community as possible. And so they say, we'll get the framework bill passed, and then we'll go and do the consultation so that everybody can be involved in it. I suppose the question I have as an opposition politician is, why don't you do the consultation first and then bring that forward? But is that a justifiable, from a policy perspective, is it justifiable to say we want to get this right, so let's involve as many people, and it's easier to do that once we've got the primary legislation passed? I'm just interested, from an academic perspective, what you think of that, maybe particularly from a social perspective.
I mean, I think it depends upon the policy area. There may be very specific reasons to justify it, but as a general principle, I'd say no. And you should do the consultation about the sort of the direction of policy, the options, what the options are, what the pros and cons are, and why the government has chosen a particular course over another one first. And then invariably, there may be a case for then consulting on the specific operational detail of the regulations with the affected stakeholders at the later date when the regulations come forward. But we see this quite frequently at Westminster, where legislation is brought forward. The policy process, I wouldn't say it's collapsed, but it's certainly not as recognisable as it was 20 or 30 years ago. The concept of a green paper followed by a white paper has largely gone out of the window. The policy making process has become so concertinaed, really, and unless in terms of actual sort of consultation processes, those themselves have actually deteriorated as well. The timeframes for them have reduced. And what we see at Westminster is quite often criticism that the information provided about consultations to inform a piece of legislation and an impact assessment and so on is actually relatively poor. And that's one of the regular complaints of the Delegated Powers Committee in the House of Lords. So it's a common problem. And there may be a very small number of examples where it's justifiable. But in the main, I think it's an excuse.
Thank you, Commissioner.
Daniel, you had a supplementary before we move on to Bill Kidd.
Well, I'll just weave it into my main body of questions,
right,
which actually follows on pretty closely to some of the things that have just been discussed.
Okay, we'll take you first then go into Bill.
Yeah, so I mean, I'd really like to follow on from some of the things that have just been said, but actually in particular, Dr. Skell made an interesting point around the justification for this is often given as about the sort of the pace of change, and actually critically the length of time it takes to get legislation through Parliament. Now, as a parliamentarian, and certainly in the Scottish Parliament, I would gently question that premise. If we were dealing with stage 3s in this place every day or even every week, I would say that might be. But ultimately, without using emergency procedures, you can get a short bill through this place in 3-4 months. I mean, it's not unheard of to have something introduced in September and sort of by Christmas time, depending on the length of it. So is that, I wonder if you'd agree with that insight. Secondly, is that, I would be interested in other panel members about whether or not, and I've never had any experience at Westminster, maybe the world is very different there, and certainly, I think the ability to do that sort of thing, even just having electronic voting makes it easier to do votes simply. But actually, is the more fundamental point, should we be asking government to sort of reconceive how it thinks of legislation? Should it be doing more shorter bills that are more focused? Because actually, it might find that those are easier to get through, and it's actually essentially seeking to avoid Parliament, but without necessarily the actual justification. I mean, would you sort of agree with those sorts of insights?
Mm-hmm. Yeah, certainly bumper bills, I'm thinking of like the Victims and Witnesses Bill at the moment is one that I've been focusing on recently. And it's got so much in it that elements of it have been substantively under-scrutinised, and it's been scrutinised over months and months and months. I think it's one of these areas where often you confront irregular verbs, by which I mean an inefficiency to government could be a useful process of slow deliberation. If your goal is simply to get to a conclusion and to get your policy enacted largely as you introduced it, then I'm sure parliamentary scrutiny feels like a terrible inefficiency. Yes. But I think it goes to that issue of consultation and who finds out about legislation and how it is improved. Because fundamentally, so often I find that government hasn't thought about certain issues because the officials that framed the policy haven't considered it. Indeed, often academics haven't considered an issue till they're confronted with a specific proposal and suddenly realise this is actually quite problematic. And so, although it can be a slow, iterative process, it can be quite a productive one to prevent you passing bad forms of legislation in particular. And with government consultation, if you're not asked to be involved, if you're not informed that it's ongoing, then you can result in secondary legislation being created from a very stacked deck. One of the examples which is highlighted in the evidence which is presented to you around this was Suella Braverman's proposals to change definitions of thresholds for what counts as serious disorder. She did hold a consultation on her change of policy and simply asked law enforcement officers what they thought about it. The English High Court concluded that consultation process was unlawful as a consequence. So unlike the kind of public-facing processes you have where anyone who finds out about your business can send you their thoughts and you can listen to them or not, the government process is inherently much, much more opaque about who talks to who gets listened to, and indeed when consultation responses are published, often many, many months after they've all been submitted. So I think all of that is also implicit in the sort of perceived efficiencies or inefficiencies of these parliamentary processes.
I think the point that Dr. Fox raised about kind of the loss of the kind of green paper to white paper procedure, I think is a really important one. And I'd just like to ask sort of colleagues with sort of insight into the West, is the excuse that there isn't the time valid in Westminster, or is that a bit of a sort of rationale that is convenient for the party of government as it may be? Dr. Govan, you're nodding. Yes,
I'm sympathetic. The burden on legislators is obviously really significant, and MPs have, a stacked diary, and I think perhaps more of a stacked diary than they had maybe 50 years ago, which forces them to deal with constituency issues rather than their kind of function as legislators. So I think there's a degree of truth to that, but I don't think that's an excuse to be kind of witnessing the deterioration in the quality of legislation or an increase in framework legislation. And I think, to go back to Dr. Tickle's point, it's good for a government or an executive to be able to pass legislation quickly. I don't think it's necessarily good for legislation for it to be passed quickly. And I think that's a really key distinction that shouldn't be lost sight of. One thing I might also mention that I think we've seen, particularly at Westminster, is an effort to obfuscate in skeleton legislation to say this is a problem of technical detail or science or something. And what that does is neatly shift the onus away from what are the powers being given to, okay, well, let's focus on whether the technical detail is complex enough to merit it. And that's a bit of a sleight of hand, I think, that we've seen more of.
Which also brings me neatly into my kind of the substantive questions I was wanting to ask. So I was really wanting to look at the practical changes that we could bring into parliamentary procedure, both around framework legislation as a whole, and also, I think, critically, as the panel's all already observed, it's better to think about actually the provisions within legislation and the powers that are being conferred on the executive, rather than trying to sort of decide whether it's over the line or not as a whole, as a bit of legislation. And one of the proposals that in the written submissions that we got that I was very interested was about having some sort of written agreement or guidance between the legislature and the executive. I think both Dr. Grez Hidalgo and Dr. Fox, both in their submissions, had similar proposals. Dr. Fox, I think you were describing that as being a concordat of legislative delegation. I was just wondering if you could explain a little bit more what features that should have. I mean, would that contain sort of the principles that I was alluding to in my earlier supplementary question, or what did the Hansard Society have in mind when it made that proposal?
Yes, so this arose out of our review of delegated legislation and our sort of cross-party advisory group at Westminster, and it was to address a number of the problems with the delegation of powers, and specifically this concern about the shifting boundary, or the perceived shifting boundary, between what should go in primary and what should go in delegated legislation. And the fact that in the research we've done over the last sort of 15 years or so on this, that there is really no consensus about where the line should be, and how, what should you shift it back to? If you perceive it's moved, what should we be moving it back to? So the idea was instead to establish some high-level principles to try and negotiate a consensus between government and legislatures about what legislative delegation should look like going forward. And so, for example, we've alluded to some of these examples. Should the creation of new criminal offences be as a matter of course in primary or delegated, and establish that in the Concordat. And then if, for example, government wanted to bring forward legislation which for some reason did have criminal offences to be delegated to ministers, that would then have a sort of be badged, they'd have to sign, much as they do, when they bring forward a legislation in relation to human rights or environmental principles, they'd have to acknowledge that it breached the Concordat principles. And what would follow from that then would be additional scrutiny procedures in the Parliament to address that. Mm-hmm. And the kinds of principles, I have to say, it's been very, very difficult to get consensus about what would work and how it would be structured. But the idea was to have some high-level principles about legislative preparation, about, as I say, where the boundary line should be. So, for example, not creating the bulk of the information about the creation of a public body, for example, entirely delegated to powers, but actually more on the face of the bill. Those kinds of principles were what we're looking at.
Dr. Grez Hidalgo, was your sort of proposal roughly along the same lines? Are there any other sort of elements that you want to?
Yes, I can highlight some other elements, but obviously it's quite along the lines of Dr. Fox. So my proposal starts from the firm belief that this committee has two ways of exerting influence and shaping legislation. And the first one is by preempting anticipated reactions from government. And the second one is in the formal stages of the legislative process by triggering compromises or amendments, formal amendments. So in terms of the preempted reactions, I think that either an inquiry like this one or potentially commissioning work looking at past instances, individual instances of legislative scrutiny performed by this committee, either in these two ways, the committee can reflect on what are their own principles of what is acceptable and what is not acceptable, and in terms of delimiting the appropriate scope of primary and secondary legislation, and then to come up with a guideline or sort of like document which tells the government in clear terms, sends a clear message about what the expectations of the committee are. And through that, those guidelines might be a point of call for legislative drafters, might be widely disseminated among different government departments, so the government is clearly aware of what are the expectations of the committee and might potentially stick to those expectations, especially among the level of civil servants and legislative drafters. I think that can be a very effective way of influencing legislation and can save quite a lot of time and energy in the formal stages of the legislative process. There is a model for doing this, and it's what the Delegated Powers Committee in the Lords is doing currently. They have been issuing guidelines. They did the first one in 1992, then they updated their guidelines in 2014, 2016, and in 2021. And from time to time, they held oral evidence sessions with the First Parliamentary Council, as we will be doing today, and they checked on whether the guideline is appropriately disseminated among government departments, whether the committee can contribute by offering training to civil servants so that they are aware of their expectations. And all of this helps to preempt legislation that might be considered going beyond what the expectations of the committee are. And that's a power you have to reflect on what are your expectations and what is the message that you would like to send to government. And then, obviously, there are other opportunities in the legislative process to improve the procedure, but I would rather prefer to only expand on that if you are interested.
I just like to sort of see if other members of the panel think that whether it's guidance or a concordat is a practical solution. And I wonder if I wonder if actually the nature of the discussion that we've had this morning is that it's not just principles, it's also counterfactual tests that would be required, i.e., is it foreseeable and predictable what will be done? Are there boundaries and parameters set? But principally, I would be interested. Do the other members of the panel agree that some sort of published document about how framework legislation or secondary powers will be used would be a helpful way forward, both in Holyrood and elsewhere?
Yeah, I think it would definitely be useful. I think the problem is that the guidance that the Delegated Powers and Regulatory Reform Committee have produced, they tend to go back to it and say, oh, you're not following our guidance, and this is part of the problem. But this committee would be at liberty to do a similar thing, and I think that would be a good thing in itself to have a document where you say, if we think this is a piece of framework legislation, then we want the government to be open about it and to explain exactly why they've taken this particular approach. I mean, that is a good thing in itself, but it won't, yeah, I'd caution against it sort of solving all the problems, because governments will still do what they want to do, and the evidence is there in the House of Lords Committee reports that they are frequently saying, oh, we've moaned about this before and you're still doing this particular thing. So, yeah, it would be a good thing, but it wouldn't solve the problems, I don't think.
There's some interesting points here about other procedures that you could apply, such as requiring government to make explicit statements. But there's also there was an interesting suggestion made by Dr. Gressa Dalgo, saying that the committee should have the power to delay a stage of the bill. Now, the reason I'm interested in that is because I think powers and committees in this Parliament have that power. So I sat on the Education Committee in the last Parliament, which refused to publish a Stage 1 report for the Children and Young People Information Sharing Bill, which was to correct the issues around information sharing regarding the named person policy. Now, I think that I'd be interested whether or not that ability for committees to undertake greater Stage 2 scrutiny would be helpful. But B, does it not actually... I wonder if some of these points are actually about awareness of parliamentarians as to what we are seeking to do. And it very much, I think, relates to Dr. Tickell's earlier point about, for example, interrogating the legal consequences, but also, I think, the parameters, not just the policy that's being presented in bills. So, A, do we think that codifying that kind of greater Stage 2 scrutiny would be helpful? But B, do panel think that parliamentarians need to alter how they are viewing legislation and therefore scrutinising it as it comes forward in order to deal with this?
I was very struck when Pablo was talking that really you're talking about culture almost, culture of legislation in government, culture of parliamentary scrutiny. I'm personally just generally quite sceptical about the utility of drafting rules and guidelines if no one's following them. If there aren't rules written on your heart, then it's pretty much meaningless. And I would worry, therefore, that a general statement of policy which isn't really informing how you're actually approaching the work would be problematic. And a number of the examples you've been given are about rules and processes and specific things and specific powers and specific scrutiny steps, and all of that is fundamentally important. But ultimately, the government will do what the government feels able to get away with politically. Yes. And there are, I think, some important differences between Westminster and Holyrood that are worth highlighting in this context. This is a proportional representative assembly, and therefore has a different balance to effectively a House of Commons, which is utterly dominated by a party which won a relatively modest percentage of the overall vote in first past the post terms. So you're in a different context where the current government, for example, does not have a majority, and that fact about do we have a governing majority or not may have a big impact on the level of pushback you can practically give. But ultimately, whatever's written into law and procedure and parliamentary rules, it's about making these things politically salient for you and reaching the wider public and reaching the wider media and making it meaningful. I was a bit concerned about the idea this is a dry kind of topic. It isn't. Giving the executive considerable powers to operate in a potentially arbitrary way is not a dry topic at all, and it should be something that we're all concerned about.
Are there any other sort of views on that, about this?
Yeah, I mean, the reason I'm not with you today is because I was in Cardiff yesterday afternoon giving evidence to the Senate on some of these same issues, and I said to them, you know, ultimately the greatest pushback you can give is to reject reject a regulation or reject provision in a bill. That's the thing that will make ministers sit up and listen, and departments take notice. So things like, parliamentary time is an incredibly, probably one of the most important resources an MP's and a minister's armoury. Taking up parliamentary time and making demands on them in terms of, appearing more at the dispatch box or appearing more at committees to answer and explain why they're doing what they're doing, in breach of, Cabinet Office guidance on legislation or in breach of a concordat on legislative principles, will all have some effect over time. And certainly the cultural problem is live. I mean, ultimately, we can design the perfect architectural procedural system, but if the people operating it are minded to, give the executive the powers anyway, then ultimately no scrutiny procedures are going to constrain that.
Mm-hmm. No, I think that's a really helpful insight.
So, Daniel, I'm just conscious of parliamentary time on this aspect as well, because we do have other areas to go into.
I was just going to collapse into the next area about dealing with the specific powers arising. Do you want to?
We'll deal with that later.
Okay.
Does anyone else want to come in just on the final question? Yes, Dr. Gress.
Just a small point. It seems to me that to the extent that the committee engages in dialogue with the government, it's more effective. And as far as your point is concerned, I can see that the committee intervenes in stage 1, and sometimes by the moment where the committee is reporting to stage 2, it's already able to know that the government has made some commitments through a letter where it says we are conscious of the points that you are making, and we will introduce some amendments in order to respond to some of your concerns. And then when you make your report for committee state, there might be further recommendations that have not been taken on board, and that's the moment where the government has to respond formally to your report. And the point I'm making is that it might be worth waiting when you move on to stage 3 or to stage 2 to secure that the formal response of the government is out there, available for all MSPs, so that it can inform debate and it can give a clear sense of how your concerns are being taken into account by the government, and that will lead to better scrutiny by the House.
Well, thank you. So before I move on to Bill Kidd, notwithstanding also what has been discussed so far in this area and the various suggestions and proposals that could be considered, Also, with some of the written evidence we've received, there's been suggestions regarding providing draft SSIs when a bill is produced, and there is an example of that in the past with the Public Bodies Joint Working Bill. The consultation of delegated powers by before publication has also been suggested, and should have more detailed scrutiny of SSIs, certainly before they are taken out of a draft context, and there are other suggestions too. I think the point that was raised a few moments ago, just regarding trying to get to some type of framework, pardon the use of the word, to get into a space of having better scrutiny or improved scrutiny. But would there be, with all the various suggestions that are there, would it be difficult to get into that space in the first instance? But also, could there then potentially be the situation that if it was too onerous at the very beginning, before it gets to before anything is taken out of a draft aspect, that it could just slow down any activity from government, and bearing in mind the point from Dr Tickell a moment ago with regards to, obviously this is a Parliament of minorities, the Welsh Senate will be the same, House of Commons obviously is different, Northern Ireland Parliament of minorities too. The political context is clearly important, but slowing potential legislation down for the right reason in terms of additional scrutiny, but is it always the right thing to do? Bearing in mind, I think that one of the points raised earlier too, in terms of how much more governments and politicians have been asked to look at today in contrast to, say, 40, 50, 60, 70 years ago. You all look around. So, yes, Professor Reid.
The idea of having draft SSIs when a bill is being discussed, I don't think that's really practical, because the whole point, as we've talked about often with the framework legislation, is it's meant to be providing for an uncertain and changing future. And if you're at the stage where you have the SSIs already drafted, then you don't need the framework bill. You could be producing a more solid bill. So there's a question about the scheduling, the timing of how government policy evolves and at what stage they decide, for whatever reason, that they need the bill. And I question whether that sometimes is partly because if you wait till all the bills are ready, you'd have a terrible logjam at the end. You've got nothing during the first 3 years of the Parliament and then trying to do everything in the last 2 years with all the details there. So that's a question. I think that looking at the process as a whole is important. And that means that at the framework stage, you can't have a detailed financial impact statement because you don't have the details there. At the SSI stage, you're too late. You've only got a number of days, and then you don't have the formal policy document. So either you need to have more of the information available on the finance and the regulatory impact available at the final SSSI stage, or you need to think about where the parliamentary input is best deployed. And there's an argument that that is actually in a sort of in-between stage, that many, not all as we've heard, many policies evolve in the sense that you've got the Act passed, and then you have extensive consultation on the regulations. And it's at that stage, perhaps, the Parliament could think about getting involved, because then there's time to influence the final state of the regulations. And at that stage, the government, with a bit of luck, has already done a lot of the work for you, because in the consultation responses it has gathered, you've got a lot of the evidence you need of what the stakeholders are thinking, what the key issues are, that might help to inform the committees to think a bit about the work. That relies on, A, there being a consultation, B, the government asking the right questions, which sometimes they don't. A lot of my consultation responses have a general introduction talking about the questions they should have been asked. I think they should have been asking, as opposed to the ones they actually have been. But there's a question about thinking radically about maybe the Parliament getting involved at that consultation, that draft stage, rather than only at the very beginning and at the very end.
Okay, thank you. Does anyone else want to contribute before we move on? No, okay, thank you. Bill Kidd.
Thank you, Convener. And it's still 2015. It's still 2025. Anyway, so Happy New Year to you all. Just a bit of a question here, which I think Dr Govan might have some background on, in terms of, obviously, as has been widely stated, and we all know anyway, it's been widely stated by the witnesses here today that the Scottish Parliament is not unique in this scrutinising work that it has to do. So are there lessons that we can learn or ideas from elsewhere that we can actually take forward in developing how we sort of enact the work that we've got over framework, etc.? Dr Govan, can you give us some idea on that?
Yes, absolutely. I mean, no man is an island. You know, to take Ireland as an example, there are constitutional limits on what can be applied through delegated legislation. Now, it's worth saying, of course, with the lack of a codified constitution, we're inhibited by that. But if the political will is there for Parliament to implement stringent limits on what is or isn't acceptable in skeleton legislation or whatever you want to call it, that there are a plethora of options around. Portugal has limits on the kind of material that is appropriate for delegated legislation. That, you know, the specifics are there to see in my written submission and elsewhere. But the issue then is you face a question of political will, and fundamentally you need the government to act on this rather than the committee. And again, not unique to Scotland, governments are very reluctant to inhibit their own power to use delegated legislation on matters. So, yes, there are examples. The difficult question is how you kind of getting government to bind itself with those kind of inhibitions. With those limits.
Well, just on the back of that, and anyone else obviously as well also, but would you think it would be possible for us to look as a committee into areas which other parliaments and assemblies, etc., have in order to address such items as statutory instruments, and then put these forward to the Scottish Government as suggestions and saying this works here and this works there, and could we ask that this is looked into as a possibility for future scrutiny?
I certainly don't think that could hurt. I mean, we've done a bit of work on it at the Constitution Society. My colleague Tasneem Ghazi has, I think, written to the committee with additional evidence on at this point, and commissioning future work in that regard certainly wouldn't be harmful. I'll defer to my colleagues on there.
Anyone else have any ideas?
I'm not sure if you should ask the government, frankly, in terms of that, because after all, this is a parliamentary issue about the level of scrutiny that you decide to extend towards provisions, and there are definitions of negative and affirmative instruments, I think, in the Interpretation Act, so there is a bit of a legislative underpinning which is there. But again, it goes back to that culture. Ultimately, it is what do you decide to do, formally and informally, to hold government to account for the decisions it's taken and the legislation that you pass. I'm very struck by the fact that another key theme that the Parliament's been thinking about recently has been post-legislative scrutiny, working out whether the promises and claims about how legislation would work when passed are actually borne out in practice. And frequently, of course, the answer is sometimes yes to some extent and no in some areas as well. And I think it speaks to the same thing, which is, do you make time? Is there scope within the parliamentary thinking and the frameworks you have given yourself or adopted to change how you're operating the way that Professor Reid was describing, for example, to give you a meaningful chance to influence policy? Because ultimately that's what this is about. The problem is almost the path dependency of the current process, that it's a fait accompli and you're invited to say yay or nay, and the record shows even in Westminster, despite all of these House of Lords reports, they say yay for more or less all of these proposals around secondary legislation. So ultimately it's not an off-the-peg solution, it's about your democratic culture of the Parliament. And that's within your power, it's not within the power of the government.
Yeah. Dr. Grace Hidalgo, did you have something? Yeah. You looked as though you were keen to say something.
Yes, so I will say that to the extent that you have a view about what amounts to a good practice, communicating to the government certainly will not do any harm. I will also potentially help those in charge of drafting legislation or supporting ministers in developing policies to have a clear idea of what do you think are the right ways of preparing legislation. I also guess that there is another way of thinking about this, which is a question of whether there is room for being more assertive or not. That will depend on what your views are about whether you are deferential or not with the government. But it seems to me, at least, that the Delegated Powers Committee in Westminster since 2021 is sharpening its teeth, and it's becoming more assertive in its scrutiny of the government, because, as colleagues have said, the view is that despite the fact that the guidance is available, the guidance is not being followed. And then there is the difficult question of where do we go now that we have sent a clear message and we are not having the response that we were expecting. So one possibility is to be more assertive, and that comes with some risks, because obviously every time that the committee will be asking for amendments, this will mean that their political capital will be at stake, and that's something that requires careful adjusting. But that's one possibility that could also be thought about.
Yeah, thank you. So just in a wee second, Professor Whittaker, but just to say that it's in the title of the committee that it's Delegated Powers and Law Reform. So we do have a duty, as much as anything else, to actually ensure that we do propose whatever role we have. Professor Whittaker, please.
Yeah, well, on practical solutions, I was going to add that I mentioned in my submission about the SL1 letter procedure in the Northern Ireland Assembly. So we were talking about minority governments before, and I think to the extent you've got a minority government, or you've got a party in government that needs to reach agreements with others, and that if that differs on different areas of legislation, then governments do have an incentive to try and talk to other parties and work together with other parties in a way that they might not, where you've got a single party majority with a lot of power in that sense. So that procedure is building on a bit of what Professor Reid was saying. It means that before something is officially laid, before a statutory instrument is laid, there's some discussion in the policy committee about that. And although in this procedure the government doesn't have to act on what the committee says, it's this anticipated reactions thing that we've talked about before, that if you know that your statutory instrument is going to have to go before a committee and there's going to be some discussion there, then as a government you may build that into what you're doing in advance, and that might be in governments, it might save governments time actually if they think about this in advance and then propose statutory instruments that are likely to get broad support. So you might not necessarily see lots of things being rejected when you implement a procedure like that, but it's the anticipated reaction that might make a difference to the content of those statutory instruments.
Yeah, and I can see that Dr. Fox was nodding away enthusiastically. Don't know if
Yes, just in terms of our delegated legislation review, I mean, fundamental to it is our view that we should abolish the distinction between negatives and affirmatives and established procedures, which, as was referred to earlier, some of which date back to 1946 and the Statutory Instruments Act, and procedures have sort of built then at Westminster on that. We propose the abolition of the distinction, in part because we think it's no longer helpful because of the shifting boundary between what should be in primary and what should be in secondary legislation. And the fact that, you know, what might have been deemed appropriate for the negative procedure in 1980, when a regulation is brought under a power from that Act in 2025, it'll be in a different political context, and therefore, you know, the scrutiny procedure might not today be deemed appropriate. And we've got a situation at Westminster, and I think the same is true of the devolved legislatures to an extent, where MPs are spending time scrutinising affirmative instruments where there is no concern, there is little interest, and they're having to expend that time in delegated legislation committees, and you know, both in the chamber and on the committee corridor, and yet instruments which are ascribed to the negative procedure that they do want to debate, they can't get a debate on. So we propose a much more radical sort of change, which would see instruments which are all laid in draft, don't have a procedure attached to them. They go to a sifting committee, and the sifting committee determines what the scrutiny procedure should be based on the content of the legal text as it is when it's presented by the government to Parliament, rather than based on some assumption that was made in a bill, whether it was framework or not, 5, 10, 15, 20 years ago. And then the scrutiny procedure would, you'd have different routes, varying levels of scrutiny depending upon the nature of and importance of what's actually in the legal text.
Thank you very much. Thank you.
Okay, thank you. Daniel Johnson.
Yeah, so I mean, just following on from that, I mean, it sounds almost as though you're saying, Dr. Fox, that secondary legislation or instruments, coming before Parliament should be treated as mini bills, almost by default. Is that essentially what you're saying? In that, they should be scrutinised and deliberated on in much the same way that primary legislation is deliberated and scrutinised. Is that because there is essentially no clear distinction between primary and secondary legislation now?
Well, some of them are like mini bills in the sense that, it can be 150, 200-page statutory instruments and, very, very substantive content. No, I mean, our procedures are not as onerous as the multi-stage process for primary legislation at Westminster. They would still, they go through a sifting process, like, for example, EU withdrawal instruments do at present. They'd have 10 days or 15 days to determine, whether these should go to a regulatory scrutiny committee. So at Westminster, we don't have dedicated scrutiny committees in the House of Commons, standing committees. We have these ad hoc committees that are created for 90 minutes to look at an instrument on which the members may have no knowledge, no expertise. We would have something more akin to a select committee that would look at them. It may well be that the sifting committee determines that there's no further scrutiny needed. It's a pretty anodyne, pretty straightforward, very short instrument, and it can go forward to be made. It may well be that there are some queries, whether that's legal or drafting queries or policy merits queries, that they want to put to the minister, to the department. That may be perhaps dealt with by correspondence, much like the delegated powers and the secondary legislation scrutiny committee do today. That would be one route. But then there's another route for the more contentious instruments where there are real concerns about the text, where they may want to call the minister in to actually, deal with those questions. And at the moment, the delegated legislation committees in the House of Commons, you have a 90-minute debate, and most of the time the minister can't really answer the questions and goes away and says, I will write back to you at a later date. And what we're proposing is that actually you have a more structured approach to that, and it's much more akin to appearing before a select committee. And that the Parliament has what we call a Parliamentary Office of Statutory Instruments, which brings together across both chambers the resource and the clerks, the support, the research staff necessary, with additional support brought in so that you can get the technical and policy expertise you need in areas like artificial intelligence or science or whatever it may be, that at the moment is completely missing from scrutiny of this kind of legislation. Because certainly at Westminster, I can't speak to it in the devolved parliaments, but at Westminster there's been investment in select committee scrutiny, in financial scrutiny, in terms of research capacity and expertise, but there hasn't been the same in terms of legislative scrutiny. That's largely left to the parties.
So I mean, just to open it up, I mean, drawing down a little bit in terms of, if I was to summarise sort of the broad set of recommendations about looking at specific powers, it is essentially a recommendation that we sift and consider much more taking evidence on secondary legislation and scrutinising it in more detail. In a sense, just following on from what Dr. Fox just said, we have the advantage in the Scottish Parliament that we don't have the distinction between bill committees and select committees. So in a sense, we're already got that bit. But if you look at how we scrutinise secondary legislation, it's by and large the minister will come and present the instrument, and then it's pretty much done at that point. So the suggestion seems to be a sift, probably elongating the length of time that you have that an instrument has to be laid, so that committees can then have the option of taking evidence. Is that broadly in terms of kind of a procedural? And I know there was a bit of scepticism about whether procedure will cut it in terms of dealing with this. Is that roughly what kind of the consensus view is of what Parliament should be looking at doing in terms of improving scrutiny on statutory
I should add
instruments?
there's another factor, sorry, that makes that more effective, in that we propose, at the moment, the difficulty you all have is that you either accept or reject an instrument.
Yes.
Those are only options. And one of the problems is the inability to amend.
I was going to come to that. Yeah.
That affects the motivation, if you like, of legislators to do anything about this kind of legislation and to engage with it, because what is the point? You either accept it in full or not. And it might be that you only have a concern about a particular provision within it. It might not be that you reject the whole instrument. And often what legislators are finding is they're having to accept the whole, even if they've got a concern about an aspect of it. So what we've proposed is, for want of a better phrase, conditional amendment, not of the actual legal text of the instrument, but of the approval motion. So you put it to government, we're not happy with this instrument for X reasons, go away and think about it. And they can say, we disagree with you, we're still going to put it to an approval vote, but they have to expend political capital to marshal their majority in the chamber to effectively whip against what the House has already agreed that they'd like a change on.
And the reason I was separating that bit out was because I know that there are panellists who disagree with the power to amend because of the consequential effects that might have. But I mean, essentially sifting more evidence and the possibility of amending, are those sensible procedural changes to the way that the secretary legislation should be examined? I'd be interested in views from the panel. Professor Whittaker.
Yeah, I mean, I think they are, but I sort of wish that there was a better way to solve the problem at source, because it feels like we're dealing with the symptoms here rather than the cause, which is the framework legislation in the first place. But I think we've already discussed the difficulties of trying to get governments to change on that front. But I think, yeah, that would be a better solution if you could achieve that in some way. Yeah,
I mean, I guess the response to that is that Pandora's box is already opened, and there's lots of legislation out there, so we need to deal with how governments then use it. Are there any other views on that?
I think I'd say that the Scottish experience is rather different from the Westminster one, with the more experienced committee. Certainly, I'm an advisor to the Net Zero Energy and Transport Committee, and there's a big set of regulations just now where the committee has been seeking evidence from stakeholders and maybe wanting to speak to people before the regulations are approved. But the time constraint and the quality of the information that's provided on the finance and the regulatory impact is an issue there. The sifting issue and then choosing the appropriate procedure, I think, is a lovely idea. I worry about this acceptability from the government's point of view, because what that would do to timetables, that you wouldn't know your schedule of when things are going on, and coordinating things may be difficult, but that's not an insuperable problem. And in terms of amendment, I'm one of the people who has worries about amending the actual final text. But the suggestion that Dr. Fox has made, which is not of that, but it is saying that we're not happy with it as it stands, but if you change this, there's no problem. I think that's fine. But doing a bit of refinement about that, I think you definitely don't want the final text being adjusted at the late stage where people might not realise the consequential impact.
Although I would say that's
not what Dr. Fox
that's similarly true of primary legislation, and that's constantly the argument we get back from the government when we bring forward a legislation. You've not realised what you've done. But I take the broad point, and Dr. Govan.
Just a disclaimer to say that while I would personally be fine with that consensus, the Constitution Society as an organisation doesn't support particular principles in this regard.
Noted.
Is there another something that occurred to me was about the way that information is presented by government when bills are introduced in particular. And I'm not sure whether this is an advantage or a downside or possibly both simultaneously, which is you have your policy memorandum and you have your delegated powers memorandum. And that could be taken to imply that delegated powers don't speak fundamentally to matters of policy, which is obviously untrue. And I wonder if that potentially helpful approach of saying, listen, these are where we're wanting to delegate powers to ministers, and putting that somewhere distinct almost means that it's not not part of the same policy discourse. I'm just conscious that when the Coronavirus Recovery and Reform Bill was progressing through the COVID-19 committee, that proposal gave ministers an unprecedented Henry VIII power to change legislation, and there was no discussion of it in the policy memorandum whatever, and a rather unclear discussion of it in the delegated powers memorandum. So I wonder if that bifurcation potentially causes some of the problems of not lining up delegated powers with big policy questions.
No, I agree. This was alluded to earlier, and I'll just finish on this point. I mean, I think one of the interesting tests for a minister presenting this is it could, following the next election, if a government of a very different viewpoint was elected, could they use this legislation to do something very, very different or even contrary to what you're intending? And the answer, yes or no, I think would be very instructive. And I take from the nods around the table that there's an agreement on that, but I'll hand off at that point.
Okay, thank you. That takes us on nicely to Henry VIII powers. So we're going to hand over to Jeremy Balfour in the first instance.
Sorry, excuse me, thank you. Yeah, I mean, we could spend a lot of time discussing this, and there's lots I'm sure we want to know from you. But I suppose, how appropriate are Henry VIII powers? Fundamentally, is it something we should be pushing back on? Or is it 21st century social media? It just has to happen that way now. Dr. Govan, you're shaking your head. I'm not smiling, so we'll go for
That's just my natural demeanour, I'm afraid. I'd take a maximalist view of this. I think it's very difficult to envisage situations where Henry VIII powers are appropriate. At Westminster, we have this argument that you know, if you have a kind of knockback on Human Rights Act grounds, then there should be Henry VIII powers to kind of deal with that. But I think even in that case, we've not seen that be very effective. So, you know, if you show me a good use of a Henry VIII power, I'll step back. But I've yet to see really great ones.
Are we in agreement on that, or is anyone a Henry VIII fan?
Well, it's a Wolf Hall related question. I suppose just to stress what I said at the beginning, to describe it as a Henry VIII power is also a term of abuse. It's not a compliment. It's a reference back to his proclamation that royal authority had the same rank and force and was expected to be obeyed as parliaments. So it is again about that fundamental question about, is it appropriate for a member of the executive to be able to change the substantive law of the land? So it's about what are the prerogatives that Parliament, as opposed to the executive, should be able to exercise. I'm not sure if I'm a maximalist exactly on this. I think there can be scenarios where actually it does make sense for having minor amendments in keeping with the core purpose of a bill to be made by powers advanced by ministers, where you are expanding a definition, expanding a parliamentary reach of a policy. I'm conscious, just to take the social media example, the current reporting restrictions framework, which is set out in primary legislation with no ability to amend who counts as a publisher, means that it's a crime for newspapers to identify a child who's on trial. It's a crime for them to do so in the radio or on television. But if I did so on social media, it's not a crime for me to do that. That seems like the kind of obvious thing where, yes, primary legislation would be preferable, it would be a possibility, but actually anticipating these technological developments is the kind of thing where I can see that Henry VIII power might be appropriate. But fundamentally, in the coronavirus context, why this was controversial is it gave ministers the power, in the context of a public health emergency, to change any piece of legislation, including the emergency legislation itself, without reference to Parliament. And that, at its core, is why this is controversial.
Yep. You just can go around. Yes, please.
Yeah, I just think, I mean, if I remember correctly, the Movable Transactions Scotland Act 2023 amendment regulations you approved early today is a set of regulations amending an Act of Parliament, and didn't seem to cause that much concern. So I think that's an example where there are technical issues that are useful. So as with all these things, in this area, one of the bedeviling problems is that there's a spectrum of uses, and within that spectrum, people will argue on political grounds on different measures.
I fully agree with that point. There might be instances where Henry VIII powers can be helpful and streamline parliamentary procedures. And as Professor Reid said, there is a significant spectrum of different examples of Henry VIII powers. So Dr. Ruth Foss earlier mentioned the legislative reform orders, which are a significant Henry VIII power that maybe should not have been granted by Parliament in Westminster. And there is also an opportunity to compare, for instance, the Henry VIII powers that were given in the European Union Withdrawal Act 2018, which are constrained to be only corrective powers. And if you compare those corrective powers to domesticate EU law with the delegated powers, Henry VIII powers that were granted by the Retained EU Law Act, which was recently enacted, there is a significant difference between the scope of the powers in the first bill and in the first act and the second act. So there can be ways in which narrowly constrained Henry VIII powers can be helpful and can contribute, as Professor Reid said, and cannot be controversial either.
So just to add to the example Professor Reid provided, certainly before we broke for Christmas, this committee also looked at the Criminal Justice Modernisation and Abusive Domestic Behaviour Review bill, and also there were Henry VIII powers in that, and as a committee we agreed to what was proposed at that particular point. But so I think it does kind of highlight the level of the range of Henry VIII powers in terms of kind of more technical minor, also with the more potentially controversial aspects that are also highlighted. So I think Dr. Fox.
Yeah, I mean, just to say, from the society's perspective, I've sometimes ended up in quite difficult arguments with members of the House of Lords about this, including some very eminent judges who wanted to consign Henry VIII powers to the dustbin of history. And we've always argued that we should concentrate on the function, the purpose of the power, not the form, because as has been highlighted, there is this spectrum. And just to give one example, the 2020 Domestic Abuse Bill at Westminster, the government brought forward a proposal to have a list of specified offences, and it was going to deal with these specified offences in regulations. And actually, it was the Delegated Powers Committee in the House of Lords itself that suggested that no, actually a Henry VIII power to put a list of offences as a schedule to the bill would be better, with a power to amend that list by regulations at a later date. And we're also seeing, on a more worrying level, routine inclusion of a Henry VIII power for ministers to amend an act itself, in effect, through supplementary provisions. So placing the onus on ministers, what appears to be a tidying up measure, actually grants ministers quite wide powers to determine what changes are necessary in order to implement the legislation, including changes to the act itself. And that actually then is quite wide. So just to give two examples of the kind of spectrum of views on this and how the powers are used. So our approach is to treat Henry VIII powers much like you would treat another power and determine the process, the procedure, the scrutiny, and whether or not you accept them, dependent upon what purpose and what impact they would actually have, rather than simply because they're badged as Henry VIII.
Okay, thank you. Daniel Johnson, supplementary.
Just on that point, I mean, you've also seen, I've seen clauses that enable them, government ministers to alter any enactment as part of that tidying up clause, which I personally really object to. Just to play devil's advocate to the point that both Dr. Tickell and Dr. Gress-Hidalgo raised about potential legitimate Henry VIII powers, what stops those things being done through one-line bills, or indeed through more regular tidying up bills, that where you have a list of little tidying up, which would, in theory, if they're just tidying up, sail through Parliament, but at least have that parliamentary scrutiny? Surely that's an alternative way of dealing with those same points.
Yeah, absolutely. I mean, certainly during the COVID scrutiny, for example, the focus was very much on issues of emergency and urgency and things like that, and a range of your colleagues articulated the fact that we can do emergency bills and that's an alternative way of achieving the same goal. I suppose then you get into questions of efficiency, and as a series of like tiny one-line amendments, that's a lucky minister who gets responsibility for that and a lucky committee that gets to scrutinise it, I suppose. It's certainly a way of doing it, but actually there's often a logic. For example, we have a long list of qualifying offences and you want to add one or one's been repealed. the argument from efficiency seems more persuasive to me in that context, where it is literally a technical, albeit with substantive implications, change, as compared to a wholesale revisiting of a policy issue or a whole stretch of parliamentary legislation using this kind of executive power.
Thank you. I've got a question for Professor Reid with regards to your submission on the Henry VIII powers. I did have a chuckle when I read this particular part of your submission, and I'll quote from it. So it was question 7 from our consultation. So you wrote, there is a paradox here. The more that the use of framework legislation is avoided, the more specific details will have to be included in the primary legislation, and therefore the greater the need to allow Henry VIII powers to avoid Parliament being clogged up with primary legislation to achieve non-controversial legislative maintenance. Now, in terms of what Professor Reid has said, I'll come back to you in a moment, Professor Reid. Just, I think it'd be interesting, just in terms of others around the table, to do you agree with what Professor Reid has suggested, or do you think Professor Reid is potentially kind of overstepping his considerations in this area?
Question. I don't know in terms of...
I'll finish this part of the session.
No, but I think it's probably... I mean, here's one of the core things, that one of the core tragedies of the human experience is that multiple things which are mutually incompatible are all important. We're looking often in black and white terms, when in fact our public life is so often dominated by ideas that it's important we have parliamentary scrutiny, but efficiency is also important. And often in politics, people want to say that it's all white or all dark and nothing in between. And actually these trade-offs are implicit in terms of privileging some values over others. So I would say Professor Reid is probably correct, and it highlights kind of some of the tragedies of public administration, that you're forced to prioritise some issues over others, and there will be consequences. Things might take longer, there might be more bills, but maybe that's better to do it that way rather than giving the executive power to act, albeit quickly, but in the shadows.
Thank you. Dr. Govan.
I think I was the devil in Mr. Johnson's devil's advocate there. I mean, as I say, I don't think we necessarily need to start an argument here. I would take a much, or not a much, but I would take a firmer line on kind of Henry VIII legislation. And I think if there's inefficiency, then that needs to be worked out on the basis of that being inefficient, you know, in bringing primary legislation rather than kind of using Henry VIII powers as a way around that. But I appreciate there are different views on this panel.
Thank you. Dr. Fox.
Yeah, I broadly agree with that view of Dr. Reid. I mean, I gave an example in our evidence of the Welfare Reform Act 2012, which introduced universal credit and resulted in Henry VIII power being used to amend 18 previous acts of Parliament. Now, those were technical changes to something which had already been approved in the Welfare Act by Parliament. So the question is, do you want to expend both government and parliamentary time for a separate bill to make those kinds of technical changes, to which in principle the Parliament has already approved? And I would suggest not. So I think that's the kind of area where the power is useful. It's the other end of the spectrum where it is a concern.
Thank you. And Professor Whittaker.
Yeah, I mean, I know less about this, I should say, than I do about some of the other things we've talked about. So, yeah, preface my remarks with that. But, yeah, I think governments with big majorities can still... I mean, I think, yeah, there is this argument about efficiency, but governments with big majorities can still do things quite fast. So I think, you know, you can get through bills quite quickly if you need to, particularly in the Westminster system. And one of the complaints about the way primary legislation is dealt with is that it's dealt with too fast as well. So I think there are ways of doing it, but I think, yeah, I'd agree that there are cases which have been laid out by other colleagues, where there are technical changes, and it makes sense from an efficiency perspective to do that. But yeah, the sort of democratic principle part of me wants to not do it that way, and wants to have it done via primary legislation, perhaps using procedures to get things through quickly.
Okay, thank you. And Dr. Grez.
I agree with the paradox that Professor Reid is raising. It seems to me that the accountability gap that arises from skeletal legislation is of such a serious nature that it might be a good trade-off to incorporate some narrowly constrained and conceived Henry VIII powers that enable the Parliament to at least have further information about what is the policy thinking of the government and to properly scrutinize those bills, and having Henry VIII powers as a compromise seems to me more or less acceptable under the circumstances. Although it's a very abstract conversation, I would say that it will always be context dependent and it's difficult to say in the abstract.
Okay, thank you. And Professor Reid, anything you'd like to add?
I think I was right. No, I think that the point's made. It's all trade-offs. You know, you're looking for the more you have in primary legislation, the less scope there is for regulations. Why do we have regulations in the first place? Because nowadays we're expecting governments to do so much, to produce so much legislation, with the extra areas of activity now added post-Brexit that governments and parliaments have to deal with. There's only a limited number of MPs, MSPs, limited amount of time. How are you going to divide up all those scarce resources? What's the balance which has impact on political accountability, political debate, public participation, and so on? It's trade-offs all the way through here, and trying to find a way through that. I think that if I was going to recommend one thing that's going to have an impact, it's picking up what's been said earlier about the importance of the political culture, and perhaps the Parliament saying no occasionally to provisions in bills and to SSIs might change, might take some of these concerns being taken a bit more seriously.
Okay, no, thank you. So before we close, Bill, do you have any final questions for the panel?
No, I just want to say thank you very much. It's been wide-ranging. I have to say there's been a lot of agreement, which has been useful, I think, to the committee to actually listen to. Thank you.
Thank you. Jeremy?
No, I mean, one area we haven't discussed, and I don't want to open a whole tin of worms on this, is I think in the Welsh, and I don't know if any of you know this, but my understanding in the Welsh system, the minister who is laying secondary legislation comes to the committee and is more involved in the scrutiny of that. I'm just wondering, perhaps, if any of you know something around that, whether that's a good thing or a bad thing, whether it gives more, you could maybe write to the committee on that, because I'm conscious of time. But I think it would be an interesting area to see if the government and the committee working more collectively together, does that give you better secondary legislation?
Okay, thank you. Daniel?
Yeah, look, I mean, I think my reflection is that I think it's been an excellent discussion. I think the observation that making a hard distinction between things that are framework bills and things that are not is not as helpful as thinking about actually how powers are framed, and also that this is much about practice and culture as it is about kind of drafting. So I think those are my takeaways, and really thank the panel for their contributions.
Okay, and Ros?
Yeah, the joy of going last is that you're either saying what everybody else has already said or nobody wants to hear what you've got to say. But no, I think thank you very much indeed for all your input. I think it was very interesting, very informative. Similar to everybody else, I think we know what the problems are. The solutions are obviously going to be harder. So thank you very much indeed.
Okay, so I want to thank all the panellists for the contribution this morning. Certainly, as colleagues said, I mean, it certainly has been a fascinating discussion, and we could have went on, no doubt, for quite some more hours, but parliamentary time doesn't allow that. But certainly, thank you very much, everyone. And if there are, notwithstanding the point to Jeremy Balfour raised regarding the Senate, but if there are any other things that you'd like to didn't put on the record today that you want to, please put it in writing and send it to the committee. So thank you very much, and with that I'll suspend briefly for a comfort break for 5 minutes. Thank you very much. And for our second panel today, can I welcome from the Office of the Parliamentary Counsel, Jessica de Mountney, the First Parliamentary Counsel, and Diggory Bailey, the Legislative Drafter. And before we start, can I remind you please not to worry about switching on the microphone, because that will be done for you. And don't feel that you need to answer every question. But if you do want to come in with something, then please just indicate and we'll take you. So certainly welcome to the Scottish Parliament, and thank you for coming to this session. Obviously very much aware of the work that the committee are looking at with regards to framework legislation and the use of the Henry VIII powers. So I'll open up the question before passing on to colleagues. So first of all, does the OPC consider that the categorising of certain primary legislation as framework is helpful or necessary, or do you think otherwise?
So I think just to kick off, it's worth just saying that obviously everything that Diggory and I say will come from a slightly different perspective from your previous witnesses, because we're here as civil servants and drafters. So I will try quite hard not to express too many opinions which seem personal rather than sort of professionally based in sort of my objective civil servant duty. I think that I would say that from a drafting perspective, it's not terrifically helpful to have rigid views of what bills are. I think it's fundamentally, if the goal of any parliament is to produce legislation that is effective and clear and properly scrutinised, the way in which they do that is probably dependent as much on context as anything, and different subjects give rise to very different considerations. I mean, for us as drafters, I'm not sure that it would make much difference to what we do in terms of how a bill would be characterised, because ultimately, as you will be aware, obviously, the policy decisions about what goes into primary and what goes into secondary are decisions for ministers. So I think from our perspective, from a drafting perspective, we wouldn't find it particularly helpful, I think. Don't know if you've got anything to add. No.
Okay, thank you. So certainly we've heard from the first panel and also in some of the evidence that we received was a consideration that there was more use of certainly Henry VIII powers and framework legislation throughout the COVID period, and also the Brexit legislation. So there's a consideration that it's become a bit more normalised as a consequence. So do you think that there has been a change in the direction that drafters receive and or in the drafting practices which makes framework legislation more likely?
So I think undoubtedly through COVID and Brexit, the speed with which it was necessary to enact legislation has led to something of a culture change. And I think that's, for me, my reflection would be that that's partly also due to just the way the world works. I think when governments are operating in a 24-hour news cycle, it is much harder to persuade people politically of the value of slowing down and producing very clearly thought through policy provisions at the point at which a bill is introduced. From my perspective, looking at instructions that we get to draft, I wouldn't observe that this comes from a desire on the part of ministers to take power for the sake of taking power. And I think one of the things I've noticed when I've read about this issue and talked to parliamentarians in Westminster is that there tends to be an assumption that that governments perhaps set out to produce what are commonly referred to as framework or skeleton bills. And actually my perception is that that's not how it works. It's much more that there is a constant pressure to do something, and the something tends to be legislation. And of course, in complex policy areas, producing good legislation takes time. And I think it's, very well documented that the current UK government has expressed a really strong desire to try to slow down the pace at which legislation is produced in order to produce bills which have more clearly thought through policy at the point at which they're introduced. As a side effect of that, it's likely that one might have fewer delegated powers where the delegated powers are there in order to fill in policy gaps that haven't been thought through at the outset. But of course, that absolutely won't mean that there won't be times when ministers make policy choices to have delegated powers for other reasons.
So just to clarify, the do something point that you touched upon, is that because of the political pressure?
I think it's a combination. Yes, I think it's a societal pressure would be my reflection.
Okay. Well, thank you. Bill Kidd.
Thank you very much, Convener, and welcome today. Thank you very much. I'm going to read a wee bit here because it's quite complicated. So, is there a conscious decision at any point to make legislation framework or as framework legislation and framework clauses, are they simply the result of drafters fulfilling direction on the purpose of primary legislation?
So I think if the question is, do we as a drafting office ever decide to produce framework legislation, the answer to that would be no. Right. What we do is to receive policy instructions and do our best to give effect to that policy within the time constraints that we're given. I suppose we might occasionally, as part of the sort of iterative nature of producing a bill, we might, on analysing a proposal, recognise that we might be in the territory where it might be helpful to have some flexibility going forward. And I was struck by the witness just previously talking about the social media and publishing of children's names, that I think that might be an example where we, bringing our kind of professional drafting expertise to bear, might say, actually, if the goal of your policy is to make sure that you stop the publication of children's names, it might be helpful for you to have a power to amend this going forward. But it would never be within our sort of remit, really, to suggest from the outset that a bill should be framework. Did you have something to add?
We will have discussions with departments about the degree to which they want that flexibility, won't we? And sometimes they will come forward with a policy proposal, and we will look at it, and they might be thinking that it will be framed as a power, and we'll say, well, do you really need a power? If you're sure this is what you want, why can't we write it out? But equally, it's just that it might be the other way round, and that is just a necessary process of them describing the policy to us and what they want to achieve both now and in the future, and us testing that and thinking through how it will be received by Parliament, and there's that iterative process to try and arrive at the best piece of legislation to give effect to the Minister's decisions.
Procedurally then, is direction on drafting, where does this originate then? Is it given primarily by ministers, civil servants or special advisors, or does it come through government departments and so on?
The decision about what procedure, what procedure will be attached to a statutory instrument. Yeah. I mean, ultimately, it's a policy question which would be decided by ministers. I imagine I know that there would be a range of circumstances in which different people might be involved in advising a minister as to where that would end up. So, yeah, that might well include special advisors and other policy officials. But ultimately, as with all decisions in relation to legislation, those sit with ministers.
And if that's framework legislation, would that then be the result of a conscious decision? At what level? I mean, at what point in the process, and under what circumstances would that kind of decision be taken?
I think the answer to that would very much depend on context. And again, it would depend on what the outcome was that was desired to be achieved. I mean, an example that illustrates this would be the bill that's currently in the UK Parliament, which is product liability and metrology. And it's one of the bills that's giving effect to Brexit, effectively, or what needs to be done post Brexit for regulatory purposes, and that has a lot of regulation making powers in it, and that will have come about. I think. I mean, I wasn't responsible for drafting it, but I think that will have come about because that's such an incredibly complex area. And trying to reproduce, effectively trying to bring into the UK the power to make regulations over areas that used to be governed by the EU, I think it would be fair to say it would be impossible on a practical scale to do that in primary legislation. So that decision to do that will have come from a starting point of the context and the desired outcome. Whereas in other circumstances, it's possible, for example, that with a particular power to make regulation, that may come about if the policy becomes apparent in the course of drafting that there's quite a lot of complexity, or that there's a greater need for flexibility than was originally imagined. I think I always come back to this, but the truth is it's such a process, drafting, and it involves so many players and so many different considerations that really it's quite difficult, I guess, to give one answer to that question.
So is it the role of the OPC then to actually sort of put proposed legislation into an understandable and logical sort of piece of production?
Yeah. Well, that's our fundamental goal and purpose, is to produce legislation that's clear and effective and comprehensible. And so part of that will be to probe quite closely the policy intentions of a minister.
Would it be helpful to us to describe the sort of drafting process briefly, which would normally start with obviously a minister's decision, and the policy will be worked up by policy officials in the relevant instructing department, who will then work with lawyers in the department who will prepare legal instructions, which will typically set out what the aim to be achieved is, what the existing law is, how they think it might need to be changed. It will deal with sort of commencement extent, and it will deal with if they're suggesting powers, it will deal with the procedure and all everything like that. And that will normally come in the form of written instructions, which might be 5, 10, 15, 20, 30 pages long. That will be sent over to us. We will then spend some time analysing that and trying to get on top of the policy, understanding it, and thinking about how best to give effect to the policy, which sometimes is the way it's suggested in instructions, but sometimes we think we might see a different route by which you might achieve the same policy, or it might be a better route, and then we'll go back to the department, sometimes with a draft, and often with a number of questions, sort of probing, really trying to get under the skin of the issue, and then there'll be a process of discussion through meetings and correspondence to really sort of dig into it. But I mean, a lot of what we're doing is the analysis and probing and trying to really understand and explore all of the issues and things that might come up in future. And as necessary, the department will then take that back to ministers for decisions.
Is there an average time for this per?
I mean, it really depends on the context again. So, the Coronavirus Act of 2020, I have to say, was a fairly speedy process, whereas I'm trying to think, the National Security and Investment Act that I did in 20, I think that, can't remember when that was, 2020 as well, possibly. I think that was worked up over a period of 2 years, and because that was a bill on which there was quite a lot of consultation and quite a lot of public sort of discussion about what was the right thing to do. So, it really, and obviously we have small bills, we have large bills, very similar to what you would have here in the Scottish Parliament. So no, there's no set time.
Well, that's very helpful. Thank you very much.
Yeah.
Thank you.
Thank you. Ross McCall.
Good morning. It's still morning. Hello. Thanks for this. There's so much I want to pick up on, so bear with me. You've highlighted the process. Thank you very much, Diggory, for doing that. And it's not drafters that come up, whether it's framework or whether it's going to go through primary legislation. It's just the sort of morphosis of how the idea then starts to go through. That's what I'm picking up from you. So I mentioned this question before. Is there a line, in effect, that as we're going through this has been this conceptual idea, this is what we're trying to do, this is what the Minister is trying to get to, we're building up this bill and we're moving it forward, we're drafting, now it's crossed a line, it's going to have to move towards, it stays in framework or skeleton, or no, we now can see that there's a definite line and we can move this forward. Is there anything like that? Is there any process that when you're in that way?
No, absolutely not, actually. I mean, I think our starting point would always be to articulate as much of the policy on the face of the bill as a minister was happy for us to do. And I think we don't really recognise the idea that there is a dividing line between a framework bill and a non-framework bill.
Right. Yeah, that's fine. Yeah.
Can I just come out? So whilst I think it's right that we try and articulate as much as possible on the face of the bill what the policy is about, there are some circumstances where pushing stuff down into the secondary legislation might mean that everything is in the same place. If lots of the content is going to be in the secondary legislation, pushing a bit more down to the secondary legislation rather than leaving it in the primary legislation means that you just have one place for the end use of the legislation to look at, or vice versa. That might dictate sort of the arrangement. And I think that is something that is one of the considerations we're taking in mind, because we're very much thinking about clarity and rule of law and the end user.
Yeah, so that might be a factor that you take into consideration, that actually this makes more sense if we move it all to secondary.
And with Henry VIII powers, which will no doubt come on to.
Absolutely. So and you highlighted earlier on that your words were producing good legislation takes time, which I thought was very interesting, because the inference to me there is that if it's a speedy expedite process, the chances are you're moving towards not necessarily bad legislation, but certainly not good legislation. And this genie that's out the bottle of 24-hour news and this desire from elected officials to expedite the process as much as possible, to be able to be seen to be doing something. Are we in a situation where, when you're writing this, that you feel that there's a possibility, if we're just moving on this continual conveyor belt, of producing what is not necessarily good legislation?
I don't think so. I think there is always, the very existence of our office, really, as a kind of separate business unit within the civil service, is to ensure that we do our absolute utmost to keep producing clear and usable and accessible legislation. So I think that's really what my answer to that would be.
Sorry, and not by any point did I want to highlight or even intimate that the work that you were producing wasn't top quality. That was not what I meant by that. But that idea that we're not really creating good law.
Yeah, I mean, we live in challenging times in terms of producing clear and precise legislation, because the pressures are different. I'd started drafting in 1997, and the world is a very different place now. And I think that inevitably has led to some changes in the way that we do things. Having said that, I think that we are acutely aware of those pressures, and I think that ministers want to produce good law, because the reason for changing the law, the reason for having legislation, is to change people's behaviour or govern people's behaviour, improve the world. And of course, you don't do that unless the legislation actually works. So I think that there is a constant awareness of the need to make sure that legislation is good. But as witnesses were saying earlier, there's forever a balance. And I think that we sometimes end up sort of navigating our way through that. And ultimately we have to do what we're told. Although we try, we do try quite hard to push back in terms of making sure that what we produce does work. And that my approach is always that, it's not just me being an annoying civil servant in terms of saying you've got to do this properly because that's the way it has to be done. It's much more saying if we don't do this well enough, it won't have the impact that you want it to have.
That's very helpful. Diggory, back to yourself. You went through the process of what you do and how you do it, which was very helpful. There was nothing in there about a consultation or an engagement stakeholder process. Is that something that you would get involved in when drafting at all?
I think on the whole not. That will take place generally before, well, it will either take place before it comes to us with the department, either consulting publicly or consulting specialists or stakeholders or whoever. Sometimes during the drafting process, our drafts are shared by the department with other people, stakeholders again, people with expertise to test it a bit. And then sometimes what we're working towards is actually a draft bill, which will then be published, and there will be an open consultation. Perhaps it'll be scrutinised by a select committee in Parliament. Or,
at that stage, but then it goes through.
And then it goes through, and then obviously the whole of the parliamentary process in a way is aimed at.
But not at the drafting stage in any way.
No more than I've just described.
Absolutely.
We have internal processes where we look at each other's work and we set up panels and stuff, but not consultation.
That's very helpful. Thank you very much indeed. Thank you, Convener.
Yeah, thank you. Jeremy Balfour.
Good morning, and thank you very much for coming this morning. I wonder if I could just follow up a couple of points that have come up already. Just following that point up from a colleague, in regard to one of the reasons we got told for framework bills here in Scotland is that they want to consult further once the primary legislation is in place. From a drafter's perspective, does it help you to have the consultation, all that information when you're drawing up a primary legislation, or is it more helpful from a drafting perspective to have that when you're doing secondary legislation? Or does it make no difference at all?
So we in the Parliamentary Council Office don't tend to draft secondary legislation. And I'm not sure that I've come across the idea in the UK context of producing primary so that consultation can take place. So I'm not sure I've got anything particularly helpful to say from our perspective on that. Do you?
No, I mean the consultation that does take place is normally on policy, and from our perspective, I think it doesn't really matter whether the policy has been. As long as the policy is clearly articulated to us and we can understand it, in a way, what goes before obviously goes to whether it might go to whether it's good policy or not. But from a drafting perspective, we just need to know what it is that we're trying to achieve and fully understand that it's fully worked out policy.
Okay, that's helpful. I mean, I think it's coming up to 40 years when I started doing law, which is a bit frightening. But one of the things I remember from my first year of jurisprudence was good law. The point is to make good law. And good law is that people, when it can be understood by as many people as possible, and then implemented by the courts if required. From your drafting perspective and from your vast amount of experience, do you think secondary legislation gives you good law and gives you clarity so that people know what the government of the day was trying to do?
I don't think that as long as legislation is well drafted, from an accessibility point of view, it doesn't matter whether it's primary or secondary. It's now equally accessible to the public. Certainly the UK statute book is kept up to date on a free legislation.gov website. So I don't think that in terms of accessibility, it makes much difference.
If we're dealing with an area of law, criminal law, and it's all in the statute, it's easier for people to find that information and interpret that information compared to having to look at the primary legislation and then maybe X number of secondary legislation beyond that.
I don't think that it makes a difference, but I'm speaking as a drafter who can wade my way through large amounts of material at top speed. I mean, I think generally speaking, the way that people access legislation now is so heavily electronic that if you have good sort of websites and good links, it probably makes no difference, because if you have something set out, I mean, I think if your mindset is that you're starting at the beginning and going through to the end, which was definitely my mindset, then obviously I can see that it's more challenging if you've got to get 25 different books open on a desk. But I think that probably increasingly that's not the way that people access law. I mean, I think our sort of user testing, or the National Archives who run legislation.gov.uk, their user testing suggests that the vast majority of people now access legislation electronically. And so I think the considerations are different. But that's very much a personal viewpoint. I'd be interested to know if Diggory disagrees.
I mean, I think if there's a problem with legislation being too diffuse, because it's all in lots of different places, that's a problem with legislation being diffuse rather than whether it's primary or secondary. You might have a whole area governing packaging and labelling and products or something. It could be in a single set of regulations, or you could have it all in an act, or you could have it split between the two. And I would have thought, just naturally from the starting point, if it's all in one place, it might be easier. But I'm not sure if that's a point about primary and secondary so much as whether it's too sort of the law is too sort of atomised across lots of different instruments.
Yeah. I mean, that's a fair point, and perhaps I'm just showing my age here. Moving us on slightly, and I think you probably answered this, but just so I can clarify exactly, in regard to policy development, that's not really your area. You get sent instructions. This is what we want. Turn it into legal language for whatever you want. Is that correct? You're not really involved in the kind of what lies behind that policy?
So the theory is that the academic theory behind the way we draft is exactly as you say. In practice, of course, the process of drafting will quite often expose policy questions, and I always say that if something's really difficult to draft, it's usually because the policy's bad. And I think that's a very simplistic way of kind of saying that the answer to your question is not entirely yes or no, because I think that the very process of drafting will sometimes expose issues, which will then mean that our drafting input and analysis will have an impact on where things end up. But any decisions are not for us. I think that's very fair to say.
Okay. I think finally from me right here, obviously the House of Lords Delegated Power and Regulatory Reform Committee have made different comments about how this all works. Has that influenced or changed the way that you work in practice as drafters? And if so, can you give us examples of how things have changed in the light of some of their reports?
So I think we are obviously always aware of the reports from the Delegated Powers Committee, and it's a very big and continuing sort of hot topic in the UK government. So I think what that means is that we will always test very carefully with departments when they ask us to do things by subordinate legislation. We will think about whether there is a way to do it that it doesn't involve subordinate legislation, or as Diggory has said, it might sometimes be that we can see from a drafting point of view that there's a good reason to do things by subordinate. So I would say that we are just acutely aware of the likelihood of criticism from the Delegated Powers Committee, and therefore that informs quite a lot of our discussions with the department.
Thank you.
Okay, thank you. Daniel Johnson.
So yes, many of my questions have been touched on, so I may be a little bit repetitious, but I'll avoid them. But before I do that, actually, I'd like to almost start from the beginning and just be interested just to understand a little bit more about your role. So you're both lawyers sitting within the Cabinet Office, and sort of working across what Whitehall departments and what, and is that typically directly with ministers and other civil servants? I mean, could you just maybe just describe kind of the function of your office and how you interact with other parts of government?
Sure. So, yeah, we're a unit that we sit within the Cabinet Office. There's about 55 full-time equivalent drafters in the Parliamentary Council Office. And we are a central resource that is available to every government department. And we, the way our resource gets sort of parcelled out is decided effectively by a Cabinet Committee. So the Parliamentary Business and Legislation Committee is the gatekeeper, the strategic overseer of the legislative programme and thus of our drafting resources. So if a department wants a bill, the first thing that they do is to get clearance from the PBL committee to instruct us, they will get clearance to have a slot in the parliamentary programme for a bill, and then they will instruct us. So that's the sort of overview. And then in terms of the actual drafting, as Diggory's explained, we will get instructions from lawyers in the particular government department. On a day-to-day basis, most of our interaction will be with those lawyers, and we will operate lawyer to lawyer, sometimes with policy officials, occasionally with ministers, not that often. I mean, we would usually meet with ministers if there was a particular issue that was causing either problems for the minister if they were not clear about what we'd done or whether we wanted to really probe something. But generally, on a day-to-day basis, we will be working with lawyers in government departments. A bit of your question was saying, are we lawyers? Yes. So all of us as drafters are England and Wales qualified barristers or solicitors, and most of us come to the drafting profession with a few years of professional experience elsewhere. So I was a criminal barrister for a few years. We have some academics. Some people who join us from solicitors' firms. So it's a wide.
So, I mean, and it sort of raises an interesting point for me, certainly, given that the Scottish Government and I would imagine the Welsh Government are formally departments of government. I mean, do you have interactions with lawyers from devolved administrations, or is it purely Whitehall departments? And I recognise that might be on a slightly different basis, but it'd be interesting if you do have those contacts and in kind of what circumstances they arise.
So we, obviously, most of what we draft is in reserved areas.
Yes.
And to the extent that we're drafting in devolved areas, the interaction and the consultation would generally be at policy official level. So we wouldn't often have direct contact when drafting. There are certain exceptions to that. So if we do have a person, a drafter seconded to us from the who deals with Scottish aspects of, but that's not in devolved areas. That's in reserved areas. But no, I don't know.
Yeah. I mean, is there anything you noticed, therefore, in terms of sort of differences in approach and practice in terms of drafting, either specifically around kind of secondary legislation, legislative powers, and/or? So, I mean, we do so little drafting for the Senedd or the Scottish Parliament that I'm not sure. I'm not quite sure what you're. I mean, really, what I'm interested in is there the possibility of sharing best practice? Oh, sorry. Yes, and kind of obviously. Yes, there are different jurisdictions, but drafting is drafting, and in a sense, there's lots of different people all seeking to do the same job of translating policy intent into good law. And actually, is there a possibility, both generally, but actually specifically within delegated powers and Henry VIII? Although I keep saying Henry VIII, and it is clearly a pejorative term, as the previous panel pointed out. So maybe powers to amend primary legislation. Is there sort of, to what extent does that exist, and to what extent is there the possibility of exploring that in the future? So we do work closely, or we talk a lot to the drafters in the other drafting offices. So I do have every 6 months I meet with the heads of the other drafting offices, so Northern Ireland, Wales, and Scotland.
and we discuss issues that are common to all of us, problems that, you know, we're all facing. We also spend quite a lot of time talking about the best way to, where the legislatures are, I mean, in conflict's the wrong word, but where you've got different kind of goals, how we manage that, you know, because I know there's obviously quite a lot of difficulties when UK acts amend Scottish acts in devolved areas. But so we talk about all of those things, and we do talk about best practice and how to share that. I think I'm not sure that we would talk that much about the kind of principles around delegated legislation, in as much as that remains a sort of policy choice. So I think our mutual goal would be to produce legislation that's clear and accessible. That's
really helpful. I mean, on a side note, I think it's always interesting to look at how both devolved and UK government machinery kind of interact. So actually having people that are kind of at that interface is really interesting and useful. Just sort of two specific questions. A number of times you've both stated that actually kind of the goal is to provide clear and understandable legislation. So there's two sub-questions for that. And I note that the OPC has drafting guidance. So how's that set out? And specifically, and we heard from the previous panel, sometimes when we have legislation that sets up powers in secondary legislation, it's not at all clear actually what ministers will then do with it. Is that sort of scenario caught within the guidance or indeed within your broader practice? Is there a point at which you go, actually, we can't tell what this legislation is going to do? Is this the right thing to do in terms of setting it and framing it in secondary legislation?
So I think that we would, I have to confess, I don't know whether we talk about that in our drafting guidance.
Yeah. I used to chair the group that produces our drafting guidance. I think our drafting guidance is very much at a more sort of technical level rather than the sort of overall approach and policy. So there is a chapter on delegated legislation, but it's about how you express, what words you use to attract the affirmative procedure or the negative procedure, and across the different jurisdictions within the UK. But it's at that sort of technical level to sort of what words you use, rather than the question that I think you're asking, which is more about, do we have a sort of overall policy approach? And I think the answer to that is, if we're being asked for a power that we think has no colour to it and you can't really understand what it's about, that'll be a discussion that we'll be having in the department. We'll be saying, well, we need to know more in order to try and articulate the policy. And we understand perhaps that you think it might shift in future, or you need to do a consultation, or that there may be it may need to adapt to future circumstances, or business might be trying to get around the regulatory regime, so you need lots of flexibility, but we need to try to articulate that power in a way that gives people a sense of what it's really about, and convey that sort of policy idea, and that will be a discussion, sometimes a robust discussion between us and departments and policy and lawyers, until hopefully we reach a consensus. But I think the breadth of power, as I think we keep sort of going back to, I think we would regard very much as a policy question in the end.
We do often, or I have often reminded departments that if you have too wide a delegated power, you run a much bigger risk of it being challenged.
Yes.
And so that is something that we've worked a lot with departments on. And we have a statutory instrument drafting hub that's based in the Cabinet Office, which, although it's not actually part of our business unit. We do interact with them a lot. And some of the work that I've been doing with them in the last few months has been around helping departments to work out exactly what they want to do with a delegated power before we draft the delegated power. Because, of course, one of the problems is that if you're using delegated power in circumstances where you don't know what you're actually going to want to do with it, there's a much higher chance that you're going to end up with a power that you can't do what it turns out you need to do. So that's another example of where the kind of practical consequences actually come to bear on how things are drafted.
And that's a very useful clarification, actually, because I think very often, my observation is that these things work much better if you have clear guardrails, even if you are leaving the actual operation to legislation. So can I ask sort of essentially the same question about quote unquote Henry VIII powers? Let's say it's powers to amend primary legislation. I mean, is it broadly the same approach that you would take, or are there different approaches, principles, or even practice set out in your guidance with regard to those sorts of powers?
I'll let you take that because you've talked.
So, I mean, I think the sort of starting point on Henry VIII powers is we want to focus on the substance rather than the form, and I think that would dictate our approach to whether a power is sort of appropriate in terms of testing it with the department. Quite often you can express something as Henry VIII power or not express it as Henry VIII power, and it may be influenced by what the policy is, but it may be influenced by other factors such as clarity or sort of usability. So suppose that there was a policy that involves looking at an identity document. You could say you have to look at an identity document of a description specified by regs, leave all of the list of identity documents to regs. Or you could put it all on the face of the primary legislation. But then if you put it all on the face of the primary legislation, you might say, well, what if something emerges in future, a new form of digital ID or something? So you want to amend that list. And then to do that, you could take a power to amend the list. That would be the Henry VIII power. Or you could say it's these things, your passport, your driving licence, etc., or any other ID document specified in regs. But then the legislation would be split between the primary legislation with some stuff that are listed there and the rest of the list in secondary legislation. So on that, I think my starting point would be it's more helpful to have it in one place. And if we think that it can be done in a way that can easily just be slotted into that list, it would actually be better to have a Henry VIII power, put the additional documents in the primary legislation. That would be Henry VIII power. But the substance is the same, whether you're putting it in the primary or the secondary or splitting it between the two. So for me, the overriding consideration there should be what will the end user, what will the lawyer or whoever's going to be looking at this document, the act, the resulting act, what will they find most useful?
That's as an aside, an incredibly helpful insight for the members' bill that I'm currently in the process of drafting. So thank you very much. Can I just finally ask? I mean, do you have a view of kind of the frequency of the use of both Henry VIII powers and sort of secretary powers? Do you think it's sort of going up, or about the same, or are there sort of differences in the approach that you see? I mean, especially given kind of the sort of the 25 years experience that you have.
Do you know, I'm going to be really annoying and say I think I'd have to come back to you on that question, because I think anything that I say would be based on sort of perception and a general feel rather than actual evidence. I mean, I think there is probably quite a lot of studies out there answering that question in terms of numbers. Are there?
Can I just come in on that? Because I think one thing is to be very careful about numbers. Sometimes you can express a view. If you look at the current tobacco and vapes bill before the UK Parliament, you can see that there's some stuff about packaging and labelling, and you could have framed that power as you can make provision about packaging and labelling of tobacco products, and then you could have said, and that can in particular, and you could have a whole list of things that it can do, or you could split it up into 10 separate powers, 1 power or 10 powers, but how you count things, if you're just counting absolute numbers, can sometimes, I think, be a bit misleading. And actually, the broader power would have been the single power, because you'd have had to have some overarching articulation of what it was, and then lots of things saying, and you can in particular do this, that, and the other. So it might actually be better to have more powers, more focused, more targeted to deliver the actual policies wanted, rather than a broad overarching one. So not answering your question, but
no. What you're saying is, in essence, that it's more important to look at the scope and effect of what is being legislated rather than necessarily the number of particular instances or clauses, because then you're just counting.
Can be a crude measure.
Yeah, exactly.
I mean, for what it's worth, my instinct is that we are in the same place as we always were in terms of wanting to produce and governments wanting to produce legislation that does what it's intended to do, and therefore I'm not convinced that there is a greater move towards sort of just pushing everything off the face of legislation, off the face of primary, for example. And to the extent that things are, it's because the world that we live in, the sort of massive regulation that that governments are now expected to do means that as a matter of practice, there is more subordinate legislation. But I don't think, my instinct is that that's not to do with a desire to sort of take power, but that's a very instinctive feeling from sort of 28 years of drafting rather than based on any evidence at all.
So I'd just like to ask one slightly, not cheeky, but less formal question. So as two drafters speaking to a group of legislators, is there sort of, if you had one sort of plead to legislators to think about when they're thinking about turning policy into codified law, what might that be?
I think it would be to don't be frightened of the words on the page, and I worry sometimes that there's so much extraneous material that's produced around bills that people's focus is taken away, legislators' focus is taken away from the words on the page. And I think my top ask would be read what's there. And if you don't understand it, then that means we've probably got it wrong.
That's one of my favourite lines, by the way. I use that all the time. If you don't understand it, it's probably wrong. It's great.
I'll sign up to that. Cop out.
Chicken.
Thank you. Okay. Any final questions before we close?
Thank you very much.
No. Okay. Thank you very much for your time today. It's been certainly very helpful for us with regards to this piece of work. And if there are any further concerns that you have or things that you haven't said on the record today, that you'd like to do so afterwards, then please write to the committee. We will obviously be producing a report in due course, and we'll send that to yourselves as well. But certainly, thank you very much. And with that, this now concludes the public part of the meeting, and I'll move the committee into private.